Hello, everybody. Hi, I'm on Pat Cam, and I am turning this light off because I think that's too much with this camera. There we go. That's a little better. So, everything on this screen is a lot smaller. Partially because
Everything on this
fudge.
screen is a lot.
I had the chat open because I had to tell everybody that I was running late. And then my brainiac forgot to turn the volume down. Oh, thank you guys so much for putting up with me and my bloopers. Hello, Marquise Phillip, my love. The handsome man with the beard. Hello, Shelly babes. Foxtrot, good to see you. Hello, crazy old lady. I'm so sorry I accidentally lied to you. She texted me, thank God, because she woke me up, and said, "What time are you going to be on tonight?" And I said, "I'm shooting for 11:15 to 11:30." That went well. I tried. I really tried. I promise. I really did. Hi, Patrick B. Good to see you. Hello, Sheena Lee. Ooh. Oh, no. Oops. You know what? It happens. And I betcha you'll fix it. Not necessarily that but you will find a way to make it a wonderful, wonderful Easter. Come on, mouse. My mouse is... Oh, it just died. I am doing great, y'all. It just died. I got no notification. Usually I get a little notification that says you're at 10%. Nope, nothing. It just died. So, back to the old-fashioned way. Actually, back to the original mouse. This is the one Becky D got me. Hi, Earl. How you doing, buddy boy? Ha. There we go. Oh, boy. I don't know if I said hello to you, Shane, but hello, Shane. Hello, Emily. You're home from shopping. Hi, Nana Laura. Good to see you. I can hear Billy. Billy is giving us his opinion. Oh, no. April is not getting technical tonight. Well, Earl was up here. He's the tech kitty. He was trying to teach me. He was giving me pointers. Because that's what Earl does. The The actual case is at 68% right now. It's exporting still. So we will have a little bit of free time. Billy, Patrick B says hello. Yep. Yeah, he's being opinionated tonight. Hi, Ava. Hi. This camera doesn't automatically angle to you. I gotta actually adjust it. How you doing, baby girl? Yeah. How you doing? That good, huh? That good. I suppose right away, right off the bat, you want treats. Yeah. Is that how that goes? Like there's no show. There's just straight to treats. You just whopped your head. You're such a smart dog. Move your fat butt. Move that fat butt. Out. I can't get at the treats if your fat butt's in the way. Okay. Come on, Eva. Let's see. Come on, turn around. Come on over here. Turn around. Hi, Billy. Come on up. Billy, okay, buddy. I know. But you gotta let me give Ava her treats first. And she's scared of you for good reason. Yeah, you found the little pile that I had there that was not supposed to get eaten yet. Come on up, Ava. Yeah. Billy's occupied with food. So he's not going to swat you. He's not going to whop you. Hi, Robert from Cologne in Germany. How you doing, love? Of course it's Ava. The treat thief. I did not see a video. I haven't been in the Discord. I've been editing all day because this docket that I do you mind? Can we have a conversation about this first, Ava? You know you're going to get it. So can you please, hey, can you just please show us your pretty face? Oh, thank you. Chicken biscuit kisses. So, sorry. I got kitty fur up my nose. I got doggy slobber in my face. So this docket is one that it's new. It's a new judge. The docket's not new. But acquiring it, you have to manually choose how long you download for, and there's not really, like, it doesn't tell you how much of it you've gotten until after you end it. So I had one 36-hour clip and one, I think this was 25-hour clip. Yeah. Boop to snoot. So then I had to, like, obviously cut it down because it was 90% dead air. But then I had to go through and some of the cases overlapped from day to day. And so I had to go through and I had to find duplicates and remove those. And it ended up, just, it was a bit more work than usual, but the judge is I like him. I really do. He's a fast talker. It's Judge David Stansbury from Licking County, Ohio. And he's thank you. He's a really fair judge, and he's really sweet. But like some of his comments are just hilarious, And at one point he was like, the old saying, fool me once, shame on you. Fool me 6, 7, 8 times, then shame on me. Just stuff like that. The little witty stuff that I like. So we've got that. I'm going to just pull out these last few biscuits and put them there so I can get rid of this bag because it's all just powder dust. Hi, Catherine Gaston and the Ava Fan Club president. Oh, she does, and she has them. Lots of them. She gets those. She gets her cinnamon biscuits, and she gets these Rachel Ray Nutrish things that we got sent to us from an anonymous love. Happy Easter! Yay! It's official. It's officially Easter. Did everybody get their eggs hidden? Oh, honey, don't be like that. Accidents happen. Do something fun with it. Make the memories better than they would have been, You can turn it around by staying in your room and just being embarrassed and taking defeat. What does that solve? And what does that do for anybody? You'll be miserable. Everybody will be miserable around you because they'll feel bad that you're feeling so bad. Just quit it. Go out there and have a wonderful time with your family. Make the best dang turkey you've ever had in your life. Or make something completely unconventional. Call it good. Make hamburgers or sliders, chicken sliders on Hawaiian buns. Just something fun. You don't have to let it ruin your holiday. She's always been the co-host. She's the star. I'm the co-host. Ava's the star. That's how it goes. My friends' chickens would hide their eggs all over the property. Every day was Easter egg hunting. And sometimes by the time they found them, they were colored. And mighty smelly. There you go, grilled cheese sandwiches. Kendra makes her grilled cheese sandwiches with Italian seasonings sprinkled on the buttered side of the bread. So then when you grill it, the Italian seasonings, like the flavors, just enhance. Yeah, what other kind of unconventional things? There's a YouTuber that I watch. He's some kind of a political candidate for some state, but he does a lot of really funny YouTubes, shorts. And he posted one of his family's Easter tradition, and it's or maybe it was Thanksgiving tradition. Their Thanksgiving tradition they had so many like other families to go to within their family, and so they all got tired of turkey. So they do a sushi buffet every year. No, the buttered side of the bread. So she sprinkles Italian seasoning on the buttered side of the bread. Yeah, and do you know how many times I've had to throw out? Oh, I just had to throw out $25 worth of meat that I pulled out of the freezer to have Kendra make, and she wasn't in the mood for that kind of meat. And we all just kept thinking, it's got one more day. It's got one more day. It did not have one more day. I finally had decided, okay, I'm going to make jerky out of it. That way it would be fine. And I opened up the package and no. There was no amount of cure and seasonings that could have cured this meat. It was a day too far gone. So I buried it in the compost. Well, not really buried. I kind of scooted the dirt a little to the side and dropped it in and kind of flopped it back over. That was the best I could muster. Not the inside of it. No. You butter one side of one slice and one side of another slice. And then you put the cheese in the middle, and the buttered sides are the outsides. Because if you put butter on the inside, it's just going to get wet. It's not going to toast. Well, that makes a difference, I guess. It's up to you, sweetie. It's up to you. I still say make the best you can of it. Because you know what? They are your family, and they're not going to be around forever. Gravy on the grill. Who are you people? What are you doing to my grilled cheese sandwich? It's bad enough with the Italian seasoning and garlic. But it's okay because it's Italian seasoning and garlic. But now y'all are gravy on the grilled cheese? No. Tomato soup? Okay. But that you're putting the grilled cheese into the tomato soup. It's acceptable. I had cream chip beef the other day. That was really good. Okay. Do both sides get toasted then? Hi, Chadesky Dum. Good to have you, sweetie. That'll definitely get you mean uncle status. I won't do mayonnaise, Patrick B. I can tell you don't like it. You've mentioned that. Exactly. There are very few things that I think justify a permanent cutoff. Yeah, there's a few things. I've gone very, very, very low contact with some family members. Haven't completely cut them off, but very, very low contact with some.
Okay, We're on the record now in the Macy Klipner case. It's 23 TR.
Yay! It's done exporting. Hi, Tiana Miller. Aw, thank you. I just threw it up because I didn't know what else to do with it. Ooh, with chili. I like Jiffy cornbread with my chili. That's made in a cast iron skillet. My gosh, that's some good Southern cooking. Now, here's the thing. What kind of gravy, though? Because you have your meat gravies, like, the chicken and the beef and the turkey gravy. But then, some places call spaghetti sauce gravy. Now that I would allow on a grilled cheese. Yeah. That's some good stuff. I don't think salsa is referred to as gravy. But I definitely know spaghetti sauce is. And then I definitely know the meat-based gravies. And then there's the cream gravies too. Like the cream chip beef. That's gravy. And sausage gravy. So you've got to narrow this window down for me. It is really good. Making it from scratch, like actual chipped beef, it comes in this jar. And it's really, really expensive. But you can get away with Carl Buttig beef. It's the dirt cheapest lunch meat you can buy. Well, okay. It's the dirt cheapest lunch meat until you do the math on it, and then it's actually not as cheap as they make it seem. But it's like 80 cents a package. But when you math out how much meat you're getting in ounces versus how much you're paying, it's really not that great of a deal. But anyways, if you get the Carl Buttig beef and you chop it up into little squares, right? You make your cream gravy, and then once your cream gravy is thickened, you throw the lunch meat right in there, and then it's done, and it very much resembles cream chip beef. Otherwise, you can buy Stouffer's has a frozen one that comes in like a little tray. It used to come in a very annoying pouch that you microwaved. Now it comes in a tray, and it's so much more handy. But yeah, it comes in a little frozen tray, and it's really, really good. And you just put it on toast. They call it shit on a shingle when you do it like that, but it's really good. Or you put it on biscuits. That's good stuff too. We're talking comfort food cooking. Ooh, mushroom gravy. On a grilled cheese, though? I don't know. I don't know if I approve of that. I like mushroom gravy on wild rice, mushroom wild rice. Oh, that's good. One day at a time, Sheena Lee. If you use real beef drippings with like shredded beef. I think that would be really good. Like make a roast in the crock pot and then yeah, you when you're done with the roast meal, and do it, not like with the celery and the carrots and the onions, just the roast. Like cook a roast in the crock pot. And then y'all have, beef sandwiches or whatever. The next day, you use what's left over with the shredded beef and the stock that's left over in the pot, and turn that into a gravy. That would be good on a grilled cheese. There are very few actual butcher shops around here. There's one here, and then there's one in the town 20 minutes away, and then there's one in the town an hour away. Like, yeah, it's hard to find an actual good butcher. Yes. Yep. It's one of my favorite foods because from the time I was 11 till I was 15, I did voluntary live in elderly care. And one of the ladies that I took care of, she was just the sweetest woman in the whole world. And there were a few like staple meals that we had. Beef roast with mashed potatoes and peas. That was like a lot of the time. And shit on a shingle was one. Yeah, there wasn't a lot of variety. She was just happy that, that she had whatever she had because she came from the Depression era. So she wasn't picky, She got stuck on a meal and that's what she got stuck on. But she's the one that got me hooked on cupwurst. And that there's only one place that I've found it, and that's the Baraboo Meat Market. And it's so good. It's a German liver sausage that you fry, and it's like the seasonings are so unique. It's got marrow in it, so it seems like it's greasy, but it's not greasy at all. It's just the marrow. Hi, Ruth Ward. Good to have you, sweetie. All right, guys. Give me a minute. I need to turn off all audio on this computer in order to open up myself onto that computer. Otherwise, there's going to be horrible, screechy feedback, and I'm not doing that. Ooh, if you think of it. Do we have a recipe thread in the Discord? Because there's been a few recipes I've been asked to share. And I don't know that we have a recipe thread. I think we should, though. I know we have a food thread. Can we just put recipes in the food thread? What y'all think of that? Hi, Lisette Finette. Good to see you, sweetie. No, I still have not found a Clallam County salve sit. But Chadaskidum, you pretty much see every Clallam County docket. If you ever see a Clallam County salve sit, you need to call me. Like, immediately call me. Please. All right. I am going to switch over to my other computer. So give me just a minute, y'all. No, don't reload the site. That is not the button I pushed. No. Okay. Okay. Sorry. Only a very momentary audio issue. Okay, I think we're good. Now I need to close this side. Oh my gosh. I don't know if you can hear her, but that's the take me out. Or maybe it was it the loud feedback, audio feedback? Did that get your dog ears going? Or do you gotta go potty? You gotta go potty? Okay. Sorry guys. Well, at least I got it put onto this computer just in time. I'll be back very quickly.
Okay, we're on the record now in the Macy Klipner case. It's 23 CRB 01572. You're Miss Klipner? The record should reflect that the defendant is present in the courtroom today with counsel Mr. Brandon Keys. He's substituting for Ms. Diatley as counsel for the defendant. We have Ms. Yeager, who, in keeping up the theme of the hearing, is substituting for Ms. Davison, who was the assistant law director. The purpose of our hearing today is to address the defendant's application for intervention in lieu of conviction. Now, the court has received a copy of the assessment conducted by the Lincoln County Alcoholism Prevention Program. It does identify substance abuse disorder and provides recommendations. One thing that I found, well, Ms. Yeager, has the state been able to review that?
Yes, Your Honor.
And Mr. Keys, has the defense seen a copy of that?
Yes, Your Honor.
So one thing that was listed in the actual assessment which caught my eye was the fact that she has a pending felony drug charge in Franklin County. So I guess my question is, if you get one shot with ILC, why would you waste it on a misdemeanor?
I don't believe you're limited, Your Honor.
All right, let me take a quick look here. Just wanted to see something here real quick. Not that I don't believe you, it's just for some reason I've always had stuck in my head that you got one opportunity to participate or to go through ILC, much like diversion. This Yeager, what's the state's position on the ability to participate in ILC or to go for ILC in more than one case?
I'm uncertain as well. I think at one point in time that it used to only have one shot of it, but I don't know if that's still the case.
Well, unfortunately, the statute itself is pretty lengthy, and it goes into a lot of...
And her preliminary hearing has been continued to tomorrow, it looks like,
Okay.
in Franklin County.
All right, well, I'm looking at the definitions of eligible offender under Section B of the statute. It doesn't say anything about has previously gone through ILC, so we're going to go on the belief that the defendant is an eligible offender. Now we just have to determine whether or not she's an appropriate candidate. Mr. Keys, is there anything you want to say in support of the application?
Yes, Your Honor, thank you. I do believe she's an eligible candidate as far as statutorily goes. No exclusionary offenses, criminal history, or anything of that nature. The charges themselves are ones which are eligible. It also wouldn't mean the seriousness of the offenses, and quite honestly would likely substantially reduce the likelihood of future criminal activity. I believe she herself is a good candidate. As the court indicated, she got the assessment from LAP, which recommended IOP. She is engaged in that. I believe she's had one so far, and the next one I think is next Thursday? Tomorrow. It also recommend that she maintain sobriety. Obviously, with the IOP, she's hoping to do that. She's also employed at Gahanna Sage Park as a nursing assistant. All those combined, I believe that she would be a good candidate, so we'd ask the court to grant the ILC.
All right, thank you, Mr. Keys. Ms. Yeager, does the state have a position on the application for ILC itself?
No, Your Honor.
All right. Well, the court is a firm believer in treatment, and so obviously there's going to be accountability if the stated intention to undergo treatment and address the substance abuse disorder is insincere or unsuccessful. So the court's going to go ahead and grant the motion. Now, Ms. Klipner, has your attorney explained to you that in order to be placed on ILC, you are required to enter pleas of guilty to the charges?
Correct.
You understand you're not required to go for ILC? Meaning nobody can force you to apply for ILC and therefore require you to plead guilty. Do you get that?
Yes, Your Honor.
And you could stand on your pleas of not guilty, forget ILC. You're presumed to be not guilty of the charges as you sit there right now. Do you realize that?
Yes, Your Honor.
In fact, it's always the prosecution's burden to prove guilt beyond a reasonable doubt before a person can be convicted. Do you understand that?
Yes, Your Honor.
And did you know that you have a right to a trial in this case with a judge or a jury?
Yes, Your Honor.
At the trial, you would have the right to both cross-examine your accusers. You would also have the right to subpoena your own witnesses to compel their attendance at trial. Are you aware of that?
Yes, Your Honor.
And did you know that if you had elected to have a trial in this case, you would not have been required to testify? Nobody could have forced you to do so, and the decision not to take the witness stand could not have been held against you in any way.
Yes, Your Honor.
Now, plea of guilty is a complete admission of guilt. If you tender a plea of guilty to these charges, you admit to committing these offenses. That means that, A, the state doesn't have to prove anything in order for a conviction to be justified. And furthermore, you will waive those rights that we've just discussed. Are you aware of that?
Yes, Your Honor.
Now, if I accept your plea, if I accept your plea here today, because I've granted your application, I'm not going to enter convictions on the record. Rather, I'll take your pleas and I'll set them aside, give you an opportunity to successfully complete the program. If you're able to do so, the charge itself would be, the charges, I should say, would be dismissed with no conviction having been entered, and you would be immediately eligible to ask the court to seal the record that they were ever even filed against you. So, obviously, that's the upside of participating in ILC. In addition to addressing the reasons why you committed the offenses. You get that?
Yes, Your Honor.
However, it comes at a cost, and that cost is your guilty pleas. Because if things don't work out for you on intervention in lieu of conviction, you can't come running back and say, well, then never mind, Judge, I want to plead not guilty and have trials because I didn't do this stuff. Realize that?
Yes, Your Honor.
So if you are unsuccessfully terminated, and we would have a hearing, you'd have a due process right to challenge whether or not it should be terminated. But if it were ultimately to be terminated, at that time the court would take the pleas that it's setting aside today, reinstate them, and at that time enter convictions. And each of these offenses is a misdemeanor of the first degree rather. Each carries up to 180 days in the county jail, up to a $1,000 fine, as well as possibly orders of restitution. Now, those sentences could also be imposed consecutively to one another, meaning back to back to back. So your total exposure on this case is actually a year and a half. Do you realize that?
Yes, Your Honor.
All right. Now, other than the benefits of being on ILC, has anybody promised you anything to get you to do this?
No, I took it upon myself to actually get help. I take accountability for my mistakes. You know, I love my job. You know, I have to be there for my residents. I've been wanting a change in my life, so no one has promised me anything.
Has anybody threatened you in any way to get you to do what you're doing
No,
today?
Your Honor.
Are you currently under the influence of any alcohol or illegal drugs?
No, Your Honor.
Do you take any medications that make it more difficult or impossible to understand what's going on around you? Like, do you take any medicine that clouds your head, that keeps you from understanding what's happening?
No, Your Honor.
Are you satisfied with the advice and representation that you've received from your attorneys?
Yes, Your Honor.
And are you a citizen of the United States of America?
Yes, Your Honor.
Then the court finds that your pleas and your waivers have been knowingly, intelligently, and voluntarily made. Court will accept the pleas and hold those in abeyance pending the defendant's performance under ILC status. Mr. Keys, did you wish to be heard regarding any specific terms and conditions of ILC?
Your Honor, we just ask the court to adopt the recommendations made by lab.
And Ms. Yeager?
Your Honor, in addition to what's in lap, we would ask, regardless of the outcome, for restitution and to the Heath Walmart in the amount of $101.59.
101.59?
Yes.
Does the defendant contest that award?
No, Your Honor.
Did you graduate from high school, Ms. Klipner?
Yes, I graduated from Northridge CTech, and I also went to college at COTC.
And what was your program at CTech?
Auto body.
Okay. Well, regardless of what ends up happening over in Franklin County, as far as this case is concerned, theft is probably one of the most career-crippling convictions that a person can get, because most employers are very wary of hiring anybody that has that type of a conviction based on trust issues. So this is a really good opportunity for you to avoid having that mark on your record, as it were. I used to always use the example of, if you could go, if you screw this up, you could meet yourself at 30 years old. The 30-year-old you would come back and want to pummel the 23-year-old you or 24-year-old you for not taking advantage of this. So don't disappoint your future self, but more importantly, don't disappoint your present self. Having granted your motion, you'll be placed under the supervision of the probation department for a period of 1 year from today, starting today, I should say. You're to enter into and successfully complete substance abuse programming, specifically intensive outpatient programming. You're not obviously to consume any alcohol or illegal drugs. You are required to submit to drug and alcohol testing if requested by any law enforcement or probation officer. You're to maintain suitable employment, pay restitution to Walmart in the amount of $101.59, and follow any other terms and conditions set by the probation department. Obviously, you'll have to pay the fees and costs associated with programs that I've ordered you to attend. Do you have any questions, Ms. Klipner?
No, Your Honor.
Mr. Keys, anything further on behalf of your client?
No, Your Honor.
Anything else on behalf of the people of the state of Ohio, Ms. Yeager?
No, Your Honor.
Very well. Then this court stands in recess.
All res.
Good luck. Okay, we're on the record here in the case of the state of Ohio versus Haley Tolliver. Is that you, ma'am?
Yes.
And the records reflect that she's here in the courtroom with her counsel, Mr. Seth Smith. We have Ms. Roberta Yeager here on behalf of the state of Ohio. Ms. Bobby Yeager here on behalf of the state of Ohio. We're here for the purpose of addressing the defendant's application for diversion.
Hey everybody, Palmyra Productions says hi. Yeah, I gave up on Ava. I left her out there. I'll have to go back out and get her in a little bit. Hello, Kara Gabrod. Good to see you. Glad to have you guys with us tonight in Palmyra Production. Oh my gosh. Thank you. I love you so much. I appreciate that. You're such a sweetheart. Oh my God, and you gifted memberships too? Thank you. Oh, I love that. Oh, that's amazing. See what happens when I take Ava out. Oh, moving is terrible. It's terrible. Yeah, you realize, Palmyra Productions, you do get that you are wrestling with her in that tainted jello. So anything you do to that jello, to her, you are also going to experience what kind of sadist kind of masochism are you into? Oh my gosh. I love that, Patrick B. That got me. That got me hard. Oh. You guys make my night. Seriously. Oh, what would I do without you? I love you guys. All right. So this is the new judge. This is Licking County, Ohio. Oh my God, Emily, burn! Palmyra Productions is going to feel the burn after that combo right there. Oh, the heart that you put up, honey, that was the health heart. After I'd made the comment about Palmyra Productions and Emily's little jello with the itching powder and Tic Tacs or thumbtacks or whatever he wants to tack up in there, and about how he's gonna have to go through whatever he does to the jello that he's wrestling Emily in. And then you put up the heart with the white cross in it is the medical heart. It was just perfect timing. Unintentional, perfect timing. But yes, I do love you too. I did not see it, whatever it was. What? Oh, what you said, the burn. Yeah, I left it alone. I know, it's so great. I have the best chat ever. No, you did great. You did great, Patrick B. That was absolutely perfect comment, perfect time. Oh. Palmyra Productions, thank you for stopping in and making an appearance and gracing us all with your presence. We absolutely love when you do that. All of us except Emily. Emily couldn't give a hoot.
I have the documentation from the probation department recommending that the application be approved. It seems to be endorsed by Assistant Law Director Yeager. And Mr. Smith, is there anything you want to say as it relates specifically to the application?
Your
Honor, I believe it was denied.
Oh, I'm sorry, it is denied. That's my
If you'd
bad.
like to approve it, though.
Yeah, I'm sure. Well, is there anything you want to say contra to the recommendation to deny?
Your Honor, I believe this is a true first offense other than traffic issues. I'm not sure exactly why it was turned down, but I will say that I know she's...
Looks like the basis was because she'd been through prior diversion.
Oh, I'm sorry about that. I read that.
2015.
I forgot about that. So,
Your Honor, then I wouldn't address anything as to the disqualification from diversion. I just ask that we move on to a change of plea.
And so if the court is to deny the application, it is your client's intention to change your plea from not guilty to guilty to the single count of theft?
It is, Your Honor.
And is that true, Ms. Tolliver?
Yes.
All right. Ms. Yeager, did you wish to be heard any further regarding the application itself?
No, Your Honor.
All right, very well. So the court's going to go ahead and formally deny the defendant's application to participate in the diversion program, but having been notified that the defendant intends to change your plea, we'll proceed with that at this time. Ms. Tolliver, are you aware that you're not required to change your plea to guilty regardless of what my decision was on the diversion?
Yes.
You understand nobody can make you plead guilty, right?
Yes.
Do you understand that you're presumed to be not guilty of the charge?
Yes.
Have you ever heard the term presumed innocent?
Yeah.
Yes, well, that's you, and every other similarly situated individual charged with a traffic or criminal offense in the United States. It's always the state's burden to prove guilt beyond a reasonable doubt before a person can be convicted. Do you understand that?
Yes.
Did you know that you have a right to a trial in this case, and it could be with a judge or it could be with a jury if you wish?
Yes.
Did you know that at that trial you would have the right to question your accusers? Meaning after the state's witnesses testified against you to say that you did what they say you did, you would have the right to question them about their testimony. Do you understand that?
Yes.
Do you also understand that you would have the right to subpoena your own witnesses to compel their attendance at the trial so that they might presumably testify favorably for you?
Yes.
And did you also know that you have a right not to testify at trial, and if you had decided you didn't want to, nobody could have forced you to, and it could not have been held against you in any way?
Yes.
Now, a plea of guilty is a complete admission of guilt. By tendering that plea, you admit to committing this offense. That means, number one, you're no longer presumed to be innocent, and the state has no burden of proof in order for me to find you guilty. And furthermore, you will be waiving those rights we've discussed, including your right to a trial. Do you realize that? And if I accept your plea and enter a conviction here today, I'm going to impose sentence upon you. This is a misdemeanor of the first degree, and it carries maximum penalties of up to 180 days in jail, up to a $1,000 fine, as well as court costs and possibly an order of restitution. Do you have any questions about any of that?
No.
Have you been threatened in any way or promised anything to get you to do what you're doing today?
No.
Are you currently under the influence of any type of alcohol or illegal drugs?
No.
Do you take any medications that affect your ability to understand what's going on around you?
No.
Are you satisfied with the advice and representation that you received from your counsel, Mr. Smith?
Yes.
And are you a citizen of the United States of America?
Yes.
And the court finds that your pleas and your waivers have been knowingly, intelligently, and voluntarily made. The court will accept the pleas, or the plea, I should say, and enter a conviction. Mr. Smith, would you care to make a statement of mitigation on behalf of your client before the court were to proceed to sentencing?
Yes, Your Honor. Ms. Tolliver is 34 years old. She works as a home health aide. I would note that this is a Walmart offense. This was not from anything to do with her employment. She has 3 kids. She lives here locally. Since the beginning of this case, she's told me this was a grave error and that she made a mistake, took ownership for her actions. She has a fairly limited criminal history, is my understanding, although apparently less limited than we believed it to be. I would just ask the court, I believe the prosecutor is deferring in this matter, I would just ask that the court not impose any jail time, possibly a fine, but minimum sanctions. Thank you.
Thank you, Mr. Smith. Ms. Tolliver, you have a right to make a statement before sentence is imposed, but you're not required to. Is there anything you would wish to say?
Your Honor, may I make one more statement? I'm sorry, I told her I would say this on her behalf. I was going to obtain a continuance for her today, and I was unable to write it due to a trial I had this morning. So it is not her fault. She is not dressed nice, in her words, nicely for court. It is my fault. I told her that she needed to plan on being here either way, and this is what she had worn to work. So I just told her I would make the court aware. I apologize.
Thank you.
It's so cute that that was her big concern.
Mr. Smith. Ms. Tolliver, as I mentioned, you do have a right to make a statement before sentence is imposed, but you're not required to. Is there anything you want to say?
No.
Ms. Yeager, did the state have a position regarding sentencing? And this is a Walmart case, so they've opted out on the Marcy's Law issue.
Yes, Your Honor, and we did want to note that the merchandise was indeed recovered at that time. The prior criminal history, it looks like it's was a 2014 case in Adams County, so that was the prior petty theft. So that's 10 years ago. With such a limited criminal history, we definitely don't think incarceration would be necessary or beneficial in any way. We would defer to the court regarding any additional sentencing.
All right. The court would note there's also a felony drug charge that was dismissed, and the records reflect for further investigation. What that means, I don't know, but there's no disposition listed, so the court infers that there was no conviction of those offenses. All right, did they submit the requisite, there we go, receipt?
Did you say the receipt, Your Honor?
Oh, I was just looking through the narrative or the submission by the officer when they submitted the matter for charges. They always include a receipt detailing what was taken, and I was able to find that.
Okay.
How old are your children, Ms. Tolliver?
My oldest is 16, 15, and 12.
Okay, well, having accepted the defendant's plea and having entered a conviction on the record, the court does have some concerns regarding possible substance abuse issues, so I'm going to suspend a 90-day jail term in its entirety, place the defendant on probation for a period of 1 year. I will order that she undergo a drug and alcohol assessment and follow up with any recommendations regarding counseling, if any. If not, then she won't have any obligations in that regard. She's not to consume any alcohol, use any illegal drugs, or abuse any prescription medication while on probation. She's to maintain suitable employment and follow any other conditions imposed by the court, or I'm sorry, by the probation department, not disapproved by the court. The fine is going to be $200. I'll order that the defendant pay the court costs. We will give you time to pay on that. You'll find out exactly how much your fine and costs combined are when you go to the clerk's office with the bailiff next. So, you know, you don't have an extensive criminal history, and what you do have is relatively old. I guess my main concern is making sure that what would appear to have been a period in your life where you did perhaps struggle with substance abuse is starting to rear its head again, and let's make sure that if it is, and my assumptions are correct, that we're going to nip that in the bud right now. All
Okay,
right?
those charges, I was just with somebody that I got in trouble.
Well, I can understand, but, you know, there's no such thing as guilt by association, but there certainly is concern by association. So if you don't have any issues in that regard, then the examiner and the assessor are probably going to make that determination and not recommend any further counseling or treatment. If they feel that perhaps there is a need for that, then they will, and you'll be required to continue with it until released in writing. So
Okay. Do I just call somewhere to do that, or?
probation will help you with that. They'll point you in the right direction. You live here in Licking County, correct?
Yeah.
So, you know, you'll probably be looking at heading to the Licking County Alcoholism Prevention Program, AKA LAP. So, do you have any other questions today, Ms. Tolliver?
I don't think so.
Anything further, Mr. Smith?
No, Your Honor, thank you.
Anything else, Ms. Yeager?
No, Your Honor.
All right, very well. Court stands adjourned. Thank you. Good luck.
All right.
Okay, we're on the record now in the case of the State of Ohio versus Brittany Hubble. It's 23 TRC 09126. And you're Ms. Hubble, ma'am?
Yes.
The record should reflect that the defendant is present in the courtroom today with her counsel, Mr. Brigden. We have Ms. Richter here on behalf of the City of Johnstown. We're here for the purpose of a change of plea. The defendant is charged with operating a vehicle while impaired and failure to maintain reasonable control, as well as driving under a 12-point suspension and an administrative license suspension as well. My understanding is that the state's going to be dismissing the 451011 charge in exchange for a plea to the remaining charges, Ms. Richter.
Yes, Your Honor.
And is that how your client intends to resolve the matter, Mr. Brigden?
Yes, Your Honor.
Is that true, Ms. Hubble?
Yes, Your Honor.
Are you aware that you don't have to do any of that, that you're presumed to be not guilty and nobody can force you to change your plea? You realize that it's the City of Johnstown here that has the state of, or the burden of proof beyond a reasonable doubt and not your burden to prove otherwise?
Yes, sir.
Do you understand that you have a right to a trial with either a judge or a jury of your peers?
Yes, Your Honor.
And did you know that at that trial, you'd have the right to both cross-examine your accusers as well as to subpoena your own witnesses to compel their attendance at the trial? You would have had the right to testify at the trial and call witnesses and present evidence if you had wanted to, but you would have been under no obligation to do so because it's not your burden. Understand?
Yes, Your Honor.
And indeed, if you had elected to have a trial, you would not have been required to testify at all. And if you had decided not to, nobody could have made you get up there. And if you didn't testify, it wouldn't have been able to be held against you in any way in the determination of your guilt or your innocence. Are you aware of that?
Yes, Your Honor.
Now, a plea of guilty is a complete admission of guilt. By tendering the plea of guilty to these charges, you admit to committing the offenses. That relieves the state of any burden of proof in order for me to find you guilty. And furthermore, it will result in a waiver of those rights that we just discussed. Are you aware of that?
Yes, Your Honor.
And you realize that if I accept your plea here today, I am going to impose sentence upon you.
Yes, Your Honor.
So it's alleged that this is a second offense within a 10-year period as far as the OVI is concerned. So the maximum penalties that you're looking at are up to 180 days in jail, up to a $1,625 fine, and up to a 7-year license suspension. Do you understand that?
Yes, Your Honor.
At a minimum, the court is required to suspend your license for at least 1 year, fine you no less than $525. And because this is a second offense within a 10-year period, it is a mandatory minimum 10 days in the county jail. Do you understand?
Yes, sir.
Now, your change of plea form indicates that the mandatory minimum was 6 days and that the maximum possible penalty for fine-wise was $1,075. And as I've just explained to you, that's not actually accurate. With that understanding, does that affect your decision to want to change your pleas?
Okay.
Okay. Driving under 12-point suspension is a first-degree misdemeanor. It carries up to 180 days jail, up to a $1,000 fine. There's no possible license suspension. However, there's a mandatory minimum 3-day jail term, but it is not required to be imposed consecutively. So it doesn't have to be imposed in a way that you would have to serve your minimum OVI sentence and then also the minimum 12-point sentence. They could be run together. Do you realize that?
Yes, sir.
And there's no provision for a license suspension for that offense. Lastly, you're charged with failure to maintain reasonable control of your vehicle, a minor misdemeanor carrying a possible $150 fine. Any questions about any of that?
No, Your Honor.
Ms. Hubble, have you been threatened in any way or promised anything in order to get you to do what you're doing?
I have not.
Are you under the influence of anything right now?
I am not.
Are you satisfied with Mr. Brigden's advice and representation?
I am.
And are you a citizen of the United States of America?
Yes, I am.
Then the court finds that the pleas and waivers have been knowingly, intelligently, and voluntarily made. I'll accept the pleas to those charges and or convictions, and I'll grant the city's motion to dismiss the one charge. Mr. Brigden, would you care to make a statement of mitigation on behalf of your client?
Yes, sure. We would ask the court to consider the minimums in this matter. Ms. Hubble, in the last 2 years, I think I mentioned earlier in pretrial that her son had passed away in 2019. She's had kind of spiraled down since then. She has been seeing a mental health provider in that time, and she is taking medication for that, and that's the allegation here today. Actually, it's not alcohol. It was that the medications that she's taking were at a higher level, which impaired her. She is working. She's a nurse's assistant. She's been at Johnstown Point. She's been doing that since November. She's been in the nursing field for about 10 plus years. Currently has 3 teenage children as well. So we would ask the court to consider the minimums and to run the 3 days on the 12-point concurrent with the minimum OVI. Thank you.
Thank you. Ms. Hubble, you have a right to make a statement if you wish before the court passes sentence, but you're not required to. Is there anything you want to say?
No, Your Honor.
And Ms. Richter, did the city wish to be heard regarding the matter of sentencing? And I think you said that there was actually an accident involving another vehicle, so technically this would be a Marcy's Law case. Has the city reached out to that individual to advise them of their right to be present and to address the court?
Yes, Your Honor. I actually spoke with her yesterday. She's fully aware of the hearing today. She was going to be present if this was going to go to a jury trial. However, she does have a 4-month-old, so she's fully aware that I made her aware that during our pretrial we discussed that the minimums would be the recommendation. She understands that.
Alrighty, thank you.
Your Honor, we would ask for a report date of April 15th as well. It's a Monday.
And we
Okay.
would have no objection. We actually discussed that in pretrial, Your Honor.
All right, very well. Does she have any jail time credit coming? Were you arrested the night you got pulled over?
It was signed.
They let you go? Okay. She was never placed under an ALS for this, right? Or did they impose one after the
I don't
urine
believe they
results
ever
came back?
imposed one.
Did you ever get a letter from the Bureau of Motor Vehicles telling you your license was under suspension after you got arrested?
Not for this case. I don't.
No.
I have her driver's record.
You have the recently checked official printout?
Yeah. I don't believe so. Would you like to? If I interpret this correctly, I don't believe that because it wasn't a refusal. She submitted urine, so there definitely wasn't a tie.
Right. She wasn't placed under the ALS at the time she was cited. Sometimes they'll go ahead and hit them with the 2255 after the results come back. Sometimes they don't, and it doesn't always make its way to the file. But you don't believe you've ever gotten anything from the Bureau saying your license is under suspension?
According to her official record, Your Honor, the last time she was notified of a suspension was August of 2023.
Okay. So you've been driving, right?
I have.
Or you don't have a vehicle?
I do.
Okay.
She doesn't have a valid driver's license.
Oh, well, yeah, duh, okay. We'll go ahead and start that today then. All right, well, Ms. Hubble, obviously, you're one of the rare exceptions to where we can actually, with a lot of certainty, point to a specific event that kind of was the turning point for you in your life. How old are your surviving children?
14, 15, and 17.
And how old was your son when he passed away?
18.
Okay. Do you actively see a counselor now?
I do.
Okay. Well, basically, the court's intention here is to just simply hook you up with services to address the reasons why you find yourself here today. I am a firm believer in treatment, and I'm going to give you the opportunity to engage in that. Now, obviously, if you prove either unwilling or unable to engage in that treatment, the court's priorities have to shift to protecting the public from any risk you might pose with additional behavior of this nature.
Right.
This was way back in, it looks like, October. You haven't had any additional legal problems since then, so that's a good sign. So hopefully, things will never be normal, obviously, but hopefully things are getting back to manageable. So, here's what we'll do. On the OVI, 180 days, 170 suspended, leaving you 10 days to actually serve. We'll talk more about that in a moment. The fine's going to be $525. That's the mandatory minimum. You'll be on probation for a year. No drinking, obviously. No alcohol, no use of illegal drugs or abuse of prescription meds. You're going to be required to continue with both drug and alcohol as well as mental health counseling. You're obviously not to use. Oh yeah, I already said that. You need to maintain suitable employment. You're required to submit to an alcohol or drug test if requested by any law enforcement or probation officer, and it'll be a 1-year license suspension effective as of today. Now, on the driving under 12-point suspension, it's a 3-day jail term with a $150 fine. That'll be imposed concurrently to the 10 days that I haven't suspended on your OVI. So you've got 10 total days to serve. And then on the failure to maintain reasonable control, that'll be a $25 fine. And there's apparently no claim for restitution, Ms. Richter.
Your Honor, I did discuss, I don't believe Ms. Hubble had insurance, but, so I think if there's going to be any claim for restitution.
It'll be through the insurance company.
Yeah.
Okay. All right. Let's see here. I'm going to grant the defendant's request to report to serve the jail term, and that will be, you'll be required to report here to this courtroom, not to the jail, but to this courtroom on Monday, April the 15th of 2024 at 11 a.m. The bail's going to give you written instructions, so there can't be any claims of any misunderstanding. Make sure you do report, because your failure to do so results in contempt proceedings be initiated, which would result in an additional 30 days in jail, and it's very likely you would simply get revoked from probation and serve the entire 180 on this as well. So you could turn a 10-day jail term into a 7-month term if you don't make it. So be sure that you're here. And by the way, if you're on time to report at 11 o'clock, you're already late, so I'd be here at about 10:45. That being said, I'm hoping this is another turning point in your life, and that this is going to be some sort of a catalyst to get you back to where you want to be and where you need to be as far as for yourself and for your family. So there's a lot of worse places to hit bottom than inside this courtroom. It's important that you recognize that you've got a lot more going in your life that you need to be there for, and that you can't be hiding behind the Ambien. Do you have any questions?
No, Your Honor.
We'll give you time to pay on your fines and your court costs. Mr. Brigden, anything further?
No, sir. Thank
Anything
you.
else on behalf of the city?
No, Your Honor.
All right,
Thank you.
very well. Good luck to you, Ms. Hubble.
I really appreciate how much compassion he showed that woman, because that particular situation can happen to any one of us. Absolutely no one is immune to the grief of the loss of anyone, but the loss of a child. I can't even imagine that kind of pain. And the depths of sorrow that one might hit during that time. And then, whatever your vice is or whatever method you use to try to drown that pain, it's obviously completely irresponsible to then get behind a wheel and risk taking someone else's child from them because of your actions. But I can understand how it happened. She clearly needs therapy. She clearly needs help. Turning to drugs or alcohol, that's not the way. It's not going to solve anything. But the judge didn't come down on her as hard as he could have. He understood why it happened, and he showed her some grace and some compassion, and he's giving her a chance. Now, she needs to embrace that chance, because she's got other kids that need her, and they're grieving too. So it was just a very sad situation. But that was one of them that I really appreciated this judge for how he treated her in that instance. And there's a little bit of everything, guys. Just so you know, there's a little bit of everything. There's some arraignments. There's some plea hearings. There's some pretrials. There's some plea changes. There's a little bit of everything. The only thing that I did cut out, I cut out a trial, because that would have pushed it over a 5-hour docket, and it was a vehicular manslaughter trial, so it was also really hard to listen to. So I just cut that one out. But this docket is over the course of 55 hours, so there's a lot to choose from. Well, Billy, what are all of these kitty cat noises that I'm hearing from you? What is up, buddy? Come on. You're being mighty vocal. Come, share the fun. The dog's not in here. I have to go out and get the dog. What's up, buddy? He's being just goofy at the moment.
Lincoln County Municipal Court is reconvened.
Please be seated. We are on the record in case number 23 TRD 08276, and it's captioned the State of Ohio versus Brandon Beach. And you're Mr. Beach, correct, sir? Breach, I'm sorry. The defendant's here in the courtroom with his counsel, or he's not here with counsel, I'm sorry. Counsel for the state is here in the form of Mr. King. We're here for the purpose of a change of plea on this driving under noncompliance suspension, which is an unclassified misdemeanor. My understanding is that you're going to be changing your plea to guilty, sir?
Yes.
And are you aware that you're not required to change your plea and nobody can force you to do so?
Yes.
You understand that as you sit there, you're presumed to be not guilty of this charge? You've heard of presumed innocent, the presumption of innocence?
Yes, I'm innocent.
Yes. The state always has the burden of proof beyond a reasonable doubt before a person can be convicted of a traffic or criminal violation. Do you understand that?
Correct.
If you plead guilty, however, you admit to committing the offense back then on September the 30th of last year. That means they don't have to prove anything in order for me to find you guilty, and you'll give up your rights that were included on your change of plea form, as well as any that I didn't otherwise mention. Understand?
Yes.
Okay. I will sentence you today if I accept your plea. Now, maximum possible penalties include community service hours, a fine of up to $1,000, and up to a 1-year suspension of your right to apply for a license. However, none of those penalties are mandatory. Do you understand?
Yes, sir.
All right. The only other question I have for you today is, are you a citizen of the United States of America?
Yes, sir.
All right. Then I find your pleas and waivers to be knowing, intelligent, and voluntary, and I'll accept the same and enter a conviction on the record. Is there anything you want to say before I decide what the fine should be here?
I have my license, I have my insurance, I have my tags, and all that stuff.
All right, good deal. Mr. King, anything from the state?
He is valid. I did verify that. Under the circumstances, I wasn't willing to dismiss it, but did indicate to him I would recommend court costs only.
Very well. You said you got your insurance?
Yes, sir.
All right. Okay, so here's what we'll do. Court will not impose any fine, but will order the defendant pay the court costs, and I'll take off proof of insurance having been shown. So that being said, congratulations on getting valid. Obviously, it wasn't easy, but make sure you keep it that way, all right? Because you know how bad it can get. All right. Anything further, Mr. King?
No, Your Honor.
All right, very well. Court stands in recess. Good luck to you. Please be seated, folks. Welcome to Lincoln County Municipal Court. I'm Judge Stansbury. We always do our jail cases first, then we'll come back to you guys with your arraignments here in the courtroom. Good afternoon, Officer Riley.
How's it going?
I'm doing all right. I understand we're flip-flopping the order.
Yep.
Okay. Well,
Get ready for some fun, guys.
then first up today is going to be Tarina Oni.
All right.
Good afternoon. Are you Miss Oni?
Yes, I am.
And Miss Oni, did you understand your rights in court based on the video presentation?
Yes, sir.
Did you receive a copy of the complaint?
I did right here, sir.
Did you read it and do you understand what it is you've been charged with?
Yes, sir.
So it looks like the Newark Police Department is alleging that on or about February the 29th of this year, within the city of Newark and Lincoln County, Ohio, you recklessly violated the terms of a protection order issued or a consent agreement approved pursuant to section 2919.26 or 3113.31, respectively, of the revised code. Commonly known as violation of a protection order, it is a misdemeanor of the first degree, carries up to 180 days jail and up to $1,000. So do you understand the charge?
I do understand the charge. I had no contact with the police at the time, though. Just want to put that in there.
So do you want to plead not guilty today?
Yes, sir. And I turned myself in for this charge because I'm clean and I'm trying to stay that way. I'm trying to do things the right way. I have a bed waiting for me at the Sally. I just want to do this little girl the right way. It's my little girl. I'm just trying to get back into her life, Your Honor.
Okay,
But I've decided to turn myself in and do it the right way.
All right. Let me take a quick look here at the file, and then we're going to address your bond. So bear with me, okay?
Yes, sir. I was hoping for a recognizance since I turned myself in. I don't plan on going anywhere. I'm doing this for my daughters. Please. My daughter actually talked me into doing this, so we decided together at lunch. My older daughter.
Well, largely for the reason that you did, in fact, turn yourself in, and there's no allegation that there were any attempts of any type of violence or any other improper behavior other than the alleged violation of the order. I will release you on your own recognizance. In light of the fact that you've indicated you intend to go into treatment, I'm going to make a condition of your bond that you not consume any alcohol or drugs, and you're to abide by the terms of any active CPO that's out there. Now, what's going to happen next is, and I'm looking at this, and it looks like this is the only reason you're being held in jail. So you're going to be released on that recognizance bond.
Yeah.
Your case gets randomly assigned to a judge and set for a trial, and we're going to send you notice by mail of when that's going to be. What is your current address, mailing address?
I have a mailing address. It's Newark, Ohio. It's lot 31, Newark, Ohio, 43055.
All right. And but you're allowed to use that as a mailing address?
Yes, sir.
All
That's
right.
my older daughter.
Okay, so here's what we're doing, Miss Oni. This gets randomly assigned to a judge set for a trial. Until and unless a lawyer gets involved on your behalf, we send notices directly to the mailing address that you provide to us. You're eligible to ask for court-appointed counsel. If you want to do that, yeah, get the application, but because you're getting out, they're not going to send it in for you. That's your job. So don't wait until the day of your trial to check up on whether or not you got a lawyer, okay?
Okay, so how do I do that? Upstairs?
Turn it in to the clerk's office, or you can fax it to him, or you can mail it to him. I don't know, maybe you take a picture on your phone and send it to him. Any other questions today?
No, thank you. I appreciate it.
All right, you may go with the officer, Miss Oni. Good luck.
Have a good day.
You do the same. All right, next we have Jeanette Morgan.
Stand at the podium right there.
Good afternoon. Are you Miss Morgan?
Yes, sir.
Miss Morgan, you're here because I issued a warrant for your arrest. It looks like back just at the end of last month, we had a status conference scheduled to talk about your case. And unfortunately, when you didn't show up, I had to issue that warrant. So what we're going to do today is simply set a bond, and we're going to get this case back on track. Okay? Can you tell me what your current mailing address is, Miss Morgan?
Mr. Judge Stansbury.
Yes, ma'am.
Preston Burkett is actually illegally using my letterheads, my envelopes, my tape, and the glue remover from when I was working at Burkett and Sanderson. Or Sanderson and Burkett.
Mm-hmm.
And with blue pen light, you can clearly see that she is not legally allowed to be representing anybody nor be an attorney. And this is the second time that I have been harassed with a competency hearing by the same lawyer and the same competency evaluator.
Okay, well, as far as if you believe that she's doing anything illegal, the police are the appropriate agency to call. If you think she's doing something improper as an attorney, you'd want to talk to the disciplinary council of the Ohio Supreme Court, okay?
I already have, sir, and it's already been granted to me. The whole Burkett office has already been granted to me. It is $1 million law firm. Okay, I've already been to the Supreme Court. It's already been ruled. They will not abide. I cannot get the police to abide by it.
Well, let me ask you this. Is there anything you want to say before I set your bond?
I'd like to dress out my suit change.
No, sir, there is not at this time.
Oh, yeah?
Okay. Well, I'm going to set your bond at $5,000, cash sure to your 10%, and we're going to get this case back on track, as I mentioned. Now, if you wish for Ms. Burkett to be removed as your counsel of record, you just need to submit a written request to me, okay? And I'll act on that. Other than that, do you have any other questions today?
No, sir, I did not.
Then you may go with the officer, Ms. Morgan. Thank you.
And that was the twist, y'all. Miss Burkett is her attorney. But she's being harassed by her attorney with this competency evaluation. Go figure. And now, according to her, she owns that law firm. It was granted to her. But she can't get the police to abide by it. I don't know why they don't just hand over the keys. Clearly, it's hers now.
All right, Officer Riley, we'll see you tomorrow. Okay, so for those of you here in the courtroom, now you got a little bit of a taste of what an arraignment's like, so if you're here for the first time, you'll know what to expect, and if you're here because you got picked up on a warrant, well, be glad you were either able to post or get an OR bond and didn't have to talk to me through the TV. So, when I call your name, you're going to come up here in front of me at the bench. Make sure you bring your rights in court form. It's one that has your initials in the boxes next to each paragraph, or at least it should, and your signature at least once. I need to verify at that point that you received a copy of your ticket or your complaint, which, by the way, you don't have to have here today, so if you didn't bring it, don't freak out. Once we're through those formalities, I'm going to ask you to enter a plea, and you have three options. You can plead not guilty, you can plead guilty, or you can plead no contest. If you don't want to be found guilty, convicted, and sentenced today, don't plead no contest, plead not guilty. A no contest plea does not admit guilt, and it cannot be used against you later on, but it's an admission of the truth of the facts that have been alleged against you, and those facts take the form of police reports, witness statements, photographs, etc. So if I look through this after you plead no contest and what you're agreeing with in here is enough to sustain the charge, I will find you guilty, enter a conviction, and sentence you today. So if you don't want that to happen, plead not guilty. If you plead not guilty, your case gets randomly assigned to a judge, set for a trial, and we'll notify you by mail of your next court date until and unless you have an attorney. When you leave here after pleading not guilty, you're going to be taken to the clerk's office and you'll be signing off on some bond paperwork, either a continuation of a bond that was either previously set or posted, or a recognizance bond issued by the court today. Your address, the one that we will have as your official address of record, is going to be located in the upper left-hand corner. It is your job to look at that and make sure it's complete, current, and correct, including any apartments, halves, rears, P.O. boxes, what have you. Because I don't know where you live. I hope you guys know where you live or where you want your mail to go. So make sure it's correct, because if it's not and it's wrong, you're probably not going to get your notice, which means you're probably not going to show up for court. And if you do not show up for court, then you and I will be talking the next time through the TV, because we'll issue a warrant for your arrest. I'll give you an opportunity to answer any questions, ask any questions when it's your turn up here, okay? Now, if on the day of your trial, after pleading not guilty, you come back, you don't want to go to trial, you just want to plead guilty or no contest, you can do that. You just tell the bailiff or the prosecutor, and you won't get a harsher sentence because you pled not guilty today. But do be aware you'll get some additional court costs, so there's that. Now, if you plead guilty, you admit that you committed whatever it is you're charged with and appearing here for. You're all presumed to be not guilty. None of you are required to plead guilty. Nobody can force you to. The state has the burden of proof beyond a reasonable doubt. And you all have the right to a trial with a judge, and if you're facing possible jail time, with a jury if you choose. If you plead guilty, all that's gone. You're going to waive that right. Your presumption's out the window. The state doesn't have to prove anything, and you won't have a trial. If I accept your plea and enter a conviction, I'll send you, and we'll be done. And if that's what you want to do, I'm more than happy to accommodate you. But be certain that's what you want to do, because it's very difficult to go backwards in the criminal justice system. The only other thing I want to talk to you guys about is lawyers. Every single one of you has the right to go out and hire an attorney of your choosing. If you are facing possible or mandatory jail time, then you are eligible to ask the court to provide an attorney for you at no cost, which we'll be happy to do if you qualify. We figure out whether you qualify or not because you turn in an application, which you conveniently have already because it was part of the paperwork you got when you checked in. If you would like to have the assistance of an attorney in your case, whether it be court-appointed or otherwise, enter a plea of not guilty today. You're going to go hire your own lawyer, start making calls as soon as you get home today to find out how much it's going to cost you, and make an honest assessment of exactly what your ability to pay that would be. If you want to go for court-appointed counsel and you're eligible, again, if you're charged with something that doesn't carry any jail time at all, you're not eligible to ask the court to give you a free lawyer. But if you are, then you can. And if you're going to go that route, turn in your application today. It too goes to the clerk where you're going next, so that's terribly convenient and easy. So don't leave the floor without doing that. Now, for those of you who are eligible to apply for counsel but want to hire your own lawyer, I would strongly recommend that you turn in your application anyway, because if you qualify, you're going to have a lawyer no matter what, even if it turns out you can't afford your own attorney. And if you can afford your own attorney, that lawyer comes in and takes over, and the court-appointed attorney is no longer on your case. What you do not want to do, if you fit into that category, is not turn in your application today, get home, make a few phone calls, and realize very quickly that you're not going to be able to afford a lawyer, and then do absolutely nothing until the next time you're supposed to be in court, when you then ask me for a continuance instead of dealing with it before you were supposed to be here. If your case is assigned to me, it's very, very possible, I would even say likely, that your request to continue the matter for that reason would be denied, and I would remind you of this little lecture that I just gave you, and if you want to argue with me further, we're actually recording everything, so I can burn a disc of it and show you what I just told you. So look, if you want to get a lawyer, get one, okay? If you don't want to get one, you don't have to get one, but we're not going to play any games and wait around and just hope things work out by themselves the next time you come back. Because I can virtually assure you that the strategy of doing nothing until you're going to be back in the courtroom and hoping things turn out well is misguided at best. So look, I don't know why each of you are here yet. I will once it's your turn, but whatever it is you're here for, just deal with it, move on with your lives, and put it behind you, okay? All right, so first up today is going to be Wendell Black.
Good afternoon, Your Honor.
Good afternoon, counsel. How are you today?
Well, how are you?
I'm doing well. Client understand his rights?
He does.
May I have your rights form, sir? Thank you. You want to acknowledge receipt of the citation?
Your Honor, we would acknowledge receipt of the citation, waive reading the complaint, possible penalties, enter a plea of not guilty, and with the court's permission, orally appeal the administrative suspension.
Okay, very well. Mr. Black, what's your current address?
There's no representative of the state to talk to about this. The citation lists this as a third offense. It's not.
Yeah. Well, obviously, I'm assuming you're going to file a jury demand.
Yes.
So we'll have a pretrial, and we'll, if it's assigned to me, I know we always schedule your ALS hearing along with the pretrial date, at which time you'll be able to speak with them. As of right now, there's not even anyone assigned to the case upstairs because that doesn't trigger until the not guilty plea is concerned. Anything you want to say about bond?
Your Honor, I think he was able to post his bond, so.
He was?
Nope, nothing further.
Okay. Are you employed, Mr. Black?
Yes, sir.
What do you do?
I'm a distribution manager.
Okay. How long have you been with the company that you work for now?
About 2 years.
All right.
Roughly almost 2 years, yeah. Just moved here.
And where'd you move from?
North Carolina.
Okay. Where about North Carolina?
Raleigh, Durham.
Okay, very good. All right. There was no accident, correct?
Correct, Your Honor.
Okay. And you have insurance on your Chevy?
Yes, sir.
I'll reflect that that's been satisfied. What I'm going to do is I'm going to go ahead and, number one, I review this. I better really get to use these little forms that I cooked up. I'm going to put on an entry that reflects the fact that you made an oral appeal of the administrative license suspension today, but that it'll be set at a later time by the judge assigned to the case.
Perfect. Thank you, Your Honor. I didn't know there was a standard form.
Oh, there isn't. It's only right here.
Oh, okay.
It's for judge's use only. Let's see, what's our case number? 24 TRC 02232. Okay, so what's going to happen is I'm going to continue the bond that he previously posted. So you don't have to post any more money to stay out of jail pending the case being resolved, but you don't get any back just yet. Now, I'm going to add a condition that you not consume any alcohol or drugs while the bond is in place. This matter is going to be automatic. Well, if they think it's a third, it'll automatically be set for a jury. If it's not, then it'll get set as a bench unless you file your jury demand. But either way, have you filed your paperwork for notice of representation?
Yes, all that should be in there with the jury demand.
Okay. It probably just hasn't made its way down to us, but once that gets processed, Mr. Black, all notices of future court hearings are going to be going through your counsel, so it's very critical that you stay in close contact with him. Anything else we need to address today?
Nothing. Thank you.
Okay, very well. Then you may go with the bailiff. Thank you. Legina Sante? You can bring him up if you want, or her. He seems to be behaving himself all right. You want to come up with Mama? Come on. You can be her lawyer. Good morning, or good afternoon. How do you pronounce your last name?
Saint.
Saint. Okay. I'm going to give this back to you, Miss Saint, because if you are going to be applying, then you're going to turn that into the clerk, and they'll take that from you. Did you watch the video about your rights in court?
Yes.
Did you understand that information?
Yes.
You obviously got a copy of your complaint, right? Did you read it and understand what you've been charged with?
Yes.
So the Pataska Police Department are alleging that on or about January the 18th of this year, in that city in Lincoln County, Ohio, that you did recklessly cause inconvenience, annoyance, or alarm to another by engaging in fighting or threatening harm to persons or property, or in violent or turbulent behavior, and failed to stop when asked. Now, that's commonly known as disorderly conduct. It's a 4th-degree misdemeanor. That's up to 30 days and up to a $250 fine. So, how would you like to plead to the charge, Miss Saint?
Not guilty.
And what is your current address, ma'am? And is there an apartment or anything like that?
Nope, it's the house.
All right. And how old's this guy?
He's 2.
All righty. Well,
He's giving me a little bit of a show here.
he'll keep you young, that's for sure. He's all right. So here's what I'm going to do. I'm going to go ahead and release you on your own recognizance, just which means you're going to sign some paperwork promising to show up for future court dates. The only condition on that bond is that you not have any violent contact with any family or household members. This case will be randomly assigned and set for a trial. We'll send you notice through the mail until and unless an attorney gets involved. Looks like you already filled that out, so don't leave the floor without turning that in today. If your request is granted, the lawyer will contact you directly. If it's denied, the court will send you a letter to that effect. All right? You have any other questions?
No.
This is a very preliminary hearing, just to make sure that you understand what you've been charged with, and to give you the opportunity to enter a plea. So if you want to just go back to where you were sitting before with your assistant, then my bailiff will be with you shortly. Take you down to the clerk's office. We'll get you on your way, okay?
Thank you so much.
You have a good day. All right. Alicia Royster? Good afternoon, Ms. Royster. You understand your rights?
Yes.
All righty. You're here because Judge George issued a warrant for your arrest last November when you failed to appear for your trial on this traffic charge. Because your case was assigned to him, the only authority I have is to set a bond for you and refer it back to his office to schedule a new hearing. Okay? So what is your current address? Okay. And obviously, it's your job to make sure that you update us, because we only know where you live based on what you tell us. All right. So you found out you had a warrant and decided to come in and take care of it?
Yeah,
Okay.
I grew up here. I just don't live here anymore, so I didn't know.
Well, and it's an old case. It's from, I mean, it's so old that Higgins was still
I
on the
know.
bench.
That's why I'm like, I didn't even know I had a. I don't come here often except for visit my family. So.
Well, you voluntarily appeared here today, and plus, I think it's an unclassified misdemeanor, if I'm correct. It might be a first-degree misdemeanor. Let me take a quick look here. Yeah, it is. So you're charged with not having a valid operator's license, and the first time you get charged with that, it's an unclassified misdemeanor, no jail time, just community service fine, license suspension. But if you have a prior conviction, regardless of how long ago it was, and the allegation here is that you have a prior conviction from 2015 for the same offense, it shoots all the way up to a first-degree misdemeanor. That's up to 180 days, up to a $1,000 fine, up to a 1-year license suspension. So I mention all that by way of saying it is a serious charge. It's not going to affect my decision. I'm still going to release you on your own recognizance. But my point being, if you want to get an attorney, now's the time to do it.
No.
And if you don't want one, you don't have to worry
No.
about it, okay?
I'm licensed and insured now. I don't know.
Surrendered. What do you do for a living?
I'm a leasing agent at an apartment complex in Columbus.
Okay. And then do you live at the same complex?
Nope.
Okay. That's probably a good thing.
Yeah.
Okay. So here's the deal. You're going to be released on your own recognizance. I'm going to refer the matter back to Judge George. You'll be notified by mail. And by the way, you can track your own case at our website. So just go to lcmunicipalcourt.com and it'll say case, search, or inquiry, and just type in your name and it'll pop up your cases.
Okay, and then so I do have to come back to court another time?
You do have to come back to court because,
Okay.
as I said, I don't have the authority to resolve your case today because I wasn't assigned to it. Judge Higgins was.
Okay.
And since Judge George was elected to his position after Judge Higgins retired, it automatically goes to him.
Okay, and so I don't have a warrant anymore?
No, I'm recalling the warrant and releasing you on your own
Okay,
recognizance.
okay.
Any other questions?
Nope, so I'm free
Just
to
have
go.
a seat where you were. The bailiff's going to be with you in a moment. You have a good day.
All right, thank you.
Christopher Sampson. All right, Mr. Sampson, come on up. You understand your rights in court today? Yes, Your Honor. All righty. You're here because I issued a warrant for your arrest earlier this month. You had a diversion hearing and weren't able to make it, so that's why the warrant went out. What we'll do today is, because we still have to have that hearing, and you still have an attorney in the form of Mr. Tabler, just simply address the warrant and set a new bond. All right?
This is a letter I'm actually in rehab right now at the counseling center.
All right. Now, have you been staying in touch with your attorney, Mr. Tabler?
I tried to get a hold of him. I asked him to email you once I found out I missed the court date.
Okay. Yeah, that's not really how it works.
Right, and
they
then
can
I got
file
a hold
paperwork, but
Right.
you're appearing voluntarily here today.
Yeah.
So, now where is the counseling center located?
It's Portsmouth.
It's in Portsmouth.
Yeah.
Okay. Did they drive you up here today? Okay. Now, to tell you how interested I am in resolving this matter, when I issued the warrant for your arrest, I set a bond of $10,000. Now, I'm going to release you on your own recognizance today because you showed up here voluntarily. But if you do miss any more court dates, it's very likely that you would not get a recognizance bond next time. Okay?
Yeah, I think it's been like 4 hours you helped me out on this one. But yeah.
Well, you know the old expression: "Fool me once, shame on you. Fool me
No,
5
yeah,
or 6
for sure.
times, shame on me."
I missed it while I was in the counseling center down there. So.
Well, better to miss it because you're in counseling than because you're in prison.
Yeah.
Although both.
You've helped me out pretty well through all my old troubles, and I just want to get it behind me for.
Well, if you're still eligible for diversion, that means that you've got a few decent things going your direction. Plus, the fact that you're actively engaged in residential programming is also an encouraging sign. So I'm going to give this back to you.
Thank you.
And as I mentioned, I'm going to release you on your own recognizance. No alcohol, no drugs. Order that the matter be reset before me, and I am going to have a copy of this entry served on Mr. Tabler so he knows that you've addressed your warrant and are back in play. Just, I would say, continue to reach out until he either answers or calls you back. Any other questions today? All right, very well. And you can track your own case online, don't forget that. All right?
Thank you.
You may go with the bailiff. Good luck. We'll see you next time. Terrence Dickey. I'm doing all right. How are you this afternoon, Ms. Dickey? Mr. Dickey? Probably be doing better if you didn't have to be in court, right?
Yeah.
All right.
I do have a warrant or something like that, they said.
You do.
I'm
It was
supposed to come
issued just
last
yesterday.
Wednesday. Yeah.
Well, it was because you didn't show up for court last Wednesday, but it didn't get issued until yesterday. We're going to address that today, okay?
I'm in class all week for probation, T for C.
Okay.
So the day I had class.
You on felony paper?
Yeah, yeah.
Okay. Who's your PO?
Madison Craft. No.
Well, let's talk about this ticket here real quick, all right? So it's alleged that on February the 21st of this year, you were driving a Yamaha motorcycle on East Main Street without a valid driver's license. Based on your previous driving record, they are alleging that you have a prior conviction for that same offense, so it elevates this one to a first-degree misdemeanor. So it is up to 180 days, up to a $1,000 fine, and up to a 1-year license suspension. But, actually, you know what? I apologize. The state has filed a motion to amend, so that's actually making it an unclassified misdemeanor.
But
So-
say, my last one was almost 3 years ago.
Well, the
That's
record
when I had the
reflects
car, yeah.
the no-ops was cited on February the 3rd of last year, and you resolved the matter in June, so.
Yeah, I was
Okay.
in jail for that, yeah.
Well, either way, it's an unclassified misdemeanor, no possible jail term, just the possibility of community service, a fine, and a license suspension. How would you like to plead?
Guilty.
Okay. Did you understand the nature and consequences of a guilty plea
Yeah,
based
yes,
upon my
sir.
explanation?
Yes,
And are you a citizen of the United States of America?
Yes, sir.
All righty. Anything else you want to say about your license?
I just got a paper in the mail, because probation, they need me to get my license.
Mm-hmm.
So they said I had to pay some fines before I get to
Yeah,
be
so
able to pay
the way
for
it works
my
is,
restitution.
yeah, the way it works is that if you have multiple cases in our court and you're paying fines, it automatically gets applied to the oldest case first.
Okay.
However, you can request in writing that you be allowed to pay your fines and costs out of order so that you can address the cases that are keeping you from being able to get valid.
Yeah.
So just tell the deputy clerk that's what you want to do, okay? And they'll
When
give
I
you the
leave here?
appropriate, yeah, she's going to take you there to
Okay.
that next office. They're going to tell you how much this is going to be, fine and costs combined, which is $125 in costs.
Yeah.
I'm not imposing a license suspension as a component of your sentence, and I'm going to go out on the assumption that you're a responsible dude and that you had insurance on the Yamaha motorcycle, because I don't see any indication that you didn't. And that'll prevent the Bureau of Motor Vehicles from imposing an additional FRA suspension.
Thank you.
So, that being said, talk to the deputy clerks in that office that you're going to next about how you can request to pay on your traffic cases that are tripping you up first.
Okay,
All
thank
right.
you.
You may go with the officer.
Appreciate it.
Thank you.
Can we take this attorney paper?
You take everything you've got over there, and she'll tell you what you need to keep and what can be thrown away.
Thank you, buddy.
All right. You have a good day.
You too.
Ludwig Guerrier?
I never would have thought that, Foxtrot. That's really interesting to me because I've heard so many less examples of that, in the court, just from the arraignments and stuff. You hear a lot more of it in Kansas and Georgia and Florida. I haven't heard too many people charged with it on these dockets, but this is the first experience of these dockets. So maybe the day that they handle those pleas, maybe I just didn't get that day. It's possible that they do them in batches or something like that, I would have thought they'd be in the general arraignments, but there is a couple that you can actually tell, even though they're not what they were charged with. You can absolutely tell that it's a factor. So, but yeah, that is really interesting, and I appreciate that you shared that. You get a little bit more intimate with places all over the country than what I do. I see the world from this little chair, and that's about it. You get to go all over. So whenever you have little tidbits of info, I really appreciate when you share that with us. You are amazing.
And I apologize. I know I probably screwed up your first name. How do you pronounce your first name?
First name is Ludwig.
Ludwig? And how do you pronounce your last name?
My last is Guerrier.
Guerrier? All right. Well, Monsieur Guerrier, do you understand your rights in court? Did you watch the video?
Yes.
Did you understand the information?
Yes.
Okay. Did you get a copy of your ticket? Did you read it?
Yes.
And looked at it and saw what you were charged with? Okay, so they're saying that you were speeding, going 75 and a 55. That's a minor misdemeanor. The maximum penalty for that offense is a fine of up to $150. They're also claiming that you were operating that vehicle without a valid driver's license. I do not have a printout of any type of driving record for you, so for that reason I have to assume that you've never been convicted of that offense before, which means that this is an unclassified misdemeanor carrying no potential jail time upon conviction. If you were to plead guilty or be convicted, you could be ordered to perform community service hours. That's where you go work at nonprofits. You could be ordered to pay a fine of up to $1,000, and you could have your right to apply for a driver's license suspended for up to 1 year. But there are no mandatory penalties, meaning the court doesn't have to do any of those things. Do you understand? So how would you like to plead?
I am new, and while I have driving in Florida.
Do you want to do a not guilty plea and then talk with the prosecutor at the next court date so you can show them what you have? You'll have to come back. So, okay, let's do that. Now, obviously, English is not your first language.
French.
French is your first language? Okay, my French is very, very rusty. I haven't spoken French in probably, well, I'm not even going to tell you, it's been so long. But would you prefer for us to have a French interpreter here for you next time? Because we will provide that at no cost to you.
I pay.
No, you don't have to pay for an interpreter. We give it to you. We provide that for free. Would you feel better to have a French interpreter with you next time? Or do you feel that your English is good enough that you can understand and you don't need an interpreter?
I understand.
So you don't need an interpreter?
Translator?
Yeah, translator.
Yes.
Do you want one? Okay, we'll get you one. Now, I'm going to go ahead and enter pleas of not guilty on your behalf, not guilty on your behalf right now. Can you tell me what your address is, please? Où habitez-vous? Où habitez-vous? In Reynoldsburg?
43068.
Okay, that's what I have too. Vous travaillez?
Yes.
Où?
Amazon.
Okay, so I'm going to put in not guilty pleas for you. I'm going to release you on what's called your own recognizance. That just means you're going to sign some paperwork promising to show up, and we'll send you a notice telling you when to come back. Bring whatever paperwork you have regarding your driver's license status with you when you come back so you can talk with the prosecutor, and we will have a French interpreter here for you the next time. Okay? French translator. So, may I have your rights form, please? Le document des droits. Okay, I told you my French was bad. You have any other questions today? Then you may go with the bill. Good luck to you.
If you need the word interpreter interpreted, then you very most definitely need an interpreter. That's just my opinion.
Moyad Cotter? I apologize if I mispronounced your name terribly.
It's Moya.
Moya? Okay, and is it Cotter?
Yeah.
Okay. Well, Mr. Cotter, do you understand your rights?
Yes.
You're here because Judge George issued a warrant for your arrest. It looks like he did that back on January the 24th. So the only thing that we have to do today, the only authority that I have is to address the warrant and your bond and to send the matter back to Judge George since it was assigned to him. Understand? Do you have a lawyer on this?
Lawyer, I
Yeah,
should
you
have.
do.
but-
Yeah, Mr. Kalsaric?
Yeah, but my case is finished. I don't know why they asked me to come back.
Well, because there was an allegation that you had violated the terms and conditions of your diversion programming.
Yeah, I finished it.
Well, they're
What,
alleging, this was filed on January the 2nd of this year, which would have been about 29 days before your diversion was scheduled to end. And they're alleging that you failed to complete the online critical thinking course. So that's something that I'm going to continue the bond that you posted, send it back to Judge George, but I'm going to also have you report down to probation to see if you can have a word with Mr. Huey to see if he can clear up the
Yes, because
confusion.
I like everything they asked me to do, like I did it.
Okay.
I have all the documents on my phone.
Who posted your bond for you?
The last time.
Oh, just a friend?
Yeah, when I went to jail.
Yeah, last night.
Yeah, that's my friend.
Or the other day, okay. All right, I bet he wants his money back, right?
Yeah.
All right. Did you give him the money to post it, or did he lend it to you?
No. He just paid in.
And you said, well, if I have to, I'll pay you back? Okay.
And I gave it to him in front of the jail.
Well, the reason I'm asking all that is because I'm going to modify your bond and I'm going to make it a recognizance bond at this time. That means the bond money will be refunded to whoever posted it in their name, regardless of whose money it was. Let's see, Judge George and R. Kalasaric. There will be some small fees that will be taken out of the total amount that was posted, but he'll get the bulk of that back. Now, let's see here also. So, your recognizance bond is conditioned upon you reporting to the probation department upon finishing your business in the clerk's office today. So check in the basement before you leave the building, and just touch base with Hans, and I think that you'll probably be able to figure some things out. Now, I'm going to give this back to you. I don't know that you necessarily intend to ask for court-appointed counsel, but if you do, you're eligible to do that. If you want to contact Mr. Kalasaric to see if he's still engaged.
Yeah, I will.
Okay.
But I need to understand why they're asking me or why they're like.
Well, that's why you're going to go down and talk to Hans real quick and see if you can talk it out with him. So that being said, where do you work, by the way?
I'm not working now.
Where were you working at the time you
I
got
was
charged?
working in a bottle shop.
At the bottle shop? Okay, all righty, very well. So any other questions today? Then you may go with the bailiff. You have a good day.
Thank you, sir.
So, other than that, I don't have anything to add.
All right, thank you.
Oh, yeah, I do. The ticket does not reflect insurance.
Mhm.
We were told by Mr. McCulloch that there is no restitution because his insurance covered it, so.
Okay.
He had Erie Insurance, Your Honor.
All right, very good. And which Kroger do you work at?
Gehanna.
And you're the manager for the entire store or department?
Store manager, sir.
He's got a good job, obviously.
And how long have you worked for Kroger?
13 years.
All right. Well, Mr. Schultz, I've presided over the drug court here in Licking County Municipal Court for almost 14 years, so I'm no stranger to the concepts of addiction as a disease, stigma associated with substance abuse disorder. We call it different things over the years. The best definition I ever heard was from an old defendant years ago that said if something causes you a problem, it is a problem. Sitting in a courtroom here having to listen to me and facing mandatory jail time for most people would be a problem. It would appear that this may be the wake-up call that you needed at that time in your life. Thankfully, from what I understand, there was no serious injuries, correct, Mr. King?
Correct. That I'm aware of.
In this case or any of your other convictions, which is somewhat just shy of miraculous, because tens of thousands of people die on the roadways of our country every year as a result of impaired driving. So thankfully, you're not sitting down the street facing an aggravated vehicular homicide charge, which would carry mandatory prison time. In drug court, a lot of our defendants presented as you can lead a horse to water, but you can't make him drink. I can refer folks for services and programming till the cows come home. But unless somebody's psychologically at a place in their life where they're prepared to do what's necessary to address, because I think all my drug court people wanted to get clean, not all of them were prepared to do what they needed to. You're off to a good start, but as you well know, the only thing you need to worry about is the next 8 hours and 6 minutes, and then you can worry about tomorrow. Because if you don't take it on a day-by-day basis, because right now you're sober. I know that you're familiar with the concept of sobriety versus recovery, but right now you're sober. You're not in recovery yet. You've got a ways to go before you can claim that. But you got a good start here, and I'm encouraged to see it. So I'm inclined to impose the mandatory minimum penalties here. On the OVI, it'll be 180 days in the county jail, 174 suspended, 1 year probation. Terms and conditions of probation, obviously, you're to undergo both the drug and alcohol as well as a mental health assessment and follow up with any recommendations regarding counseling until released in writing. You're prohibited from consuming any alcohol or illegal drugs or abusing any prescription medication. I'll leave the use of a scram monitor on your ankle at the discretion of the probation department. Quite frankly, had I conducted your arraignment, I don't know whether I would have ordered it as a condition of your bond. I know Judge George did not, but it's pretty typical for multiply convicted individuals to at least have a scram initially placed on them, so don't be surprised if they require that. You are required to immediately submit to an alcohol or drug test if requested by any law enforcement or probation officer. You maintain suitable employment. I'll impose the minimum fine of $375 in order that you pay the court costs, but I'm going to go above the mandatory minimum license suspension just given the number of priors that you have. That'll be a 2-year license suspension effective from December the 5th of last year. That can be reduced to not less than 1 year. It cannot be extended beyond the 2 years that I've imposed today, but before I would consider doing that, you need to be a lot closer to recovery than you are today. As far as the remaining minor charges on the only remaining minor charge, it'll be a $25 fine. If the state is presenting to the court that proof of insurance has been satisfied, that's good enough for me. I'll reflect that on the citation, so you won't have to worry about the bureau. Now, as far as the 3 days that you owe, I'm assuming you're asking for a report date.
Yes, sir, please.
How far out do you, well, you have to be there every day, I'm assuming, or almost every day.
When can you, the quickest you can get this out of your schedule? Just 1 second, Your Honor.
Then there's a calendar under the glass there in front of you, gentlemen.
You probably, are you looking at your work schedule? How do you feel about occupational privileges with an interlock?
Oh, he's eligible to ask for those, and he can submit the application today before he leaves. I'll review it. I never make any promises one way or another from the bench, but obviously as a first intent offender, he'd be eligible.
So that much I know. I was hoping you'd promise. Thought you appreciate this sort of a primer on the. Usually I go to Mr. King for primers on the law because he's such a knowledgeable guy. Judge, would the 9th and starting April 9th be permissible for the 3 days, please?
Any objection, Mr. King?
No, Your Honor.
All right. And I believe that is a Tuesday.
Correct, sir.
Okay, so Mr. Schultz, you're going to report here to this courtroom on Tuesday, April the 9th of this year at 11 a.m. The bailiff will give you written instructions, so there can't be any claims of any misunderstandings. I want to be upfront with you about what happens if you don't show up, not because I don't think you will, but because I think it's only fair to tell you what hell will be unleashed if you don't. Number 1, warrant gets issued for your arrest. Number 2, your probation gets revoked. Number 3, you serve all 180 days. And to add insult to injury, you get an extra 30 for contempt for not obeying the court's order to report. So that being said, as I mentioned, you worry about the next 8+ hours, and then you can worry about tomorrow. And if you do, I think the chances of you seeing me or any other judges again are going to be very slim. So do you have any questions, sir?
No, sir.
We'll give you time to pay on your fines and costs. Mr. Schmansk, anything further?
We'll pay fine and costs today.
We'll be happy to take it.
Thank
Anything
you,
further,
Judge.
Mr. King? No. All right, very well. That'll be all. Good luck to you, Mr. Schultz.
Thank you.
Court stands adjourned.
Take that to your PA.
All right, welcome to the Licking County Municipal Court. I am Judge Stansbury. I'm going to be presiding over your arraignment session. When I call your name, you're going to come up here in front of the bench right here. I'm going to be asking you for your rights in court form. That's the one that should have your initials in the boxes next to each paragraph and your signature at least once at the end. Then I need to verify that at some point in the past you received a copy of your ticket, which, by the way, you are not required to have with you today, so if you don't have it, don't freak out. If you do have it, leave it in your pocket because you don't have to show me that you got it for me to believe that you did. Now, once we're through those formalities, it's time for you to enter a plea. If you don't want to be found guilty, convicted, and sentenced today, do not plead no contest. Plead not guilty. A no contest plea does not admit guilt. It can't be used against you later on, but it's an admission of the truth of the facts that have been alleged against you. Those facts take the form of police reports, witness statements, photographs, whatever, in your case file. And if the facts in here that you're agreeing with as being true upon pleading no contest. If those are sufficient to sustain whatever it is you're charged with, I'm going to find you guilty, I'm going to enter a conviction, and I'm going to sentence you today. So if you don't want that to happen, plead not guilty. If you do that, your case is going to be randomly assigned to one of the judges of this court, and we will notify you by mail of your next court date. After pleading not guilty, you'll be taken to the clerk's office where you're going to sign off on some bond paperwork, basically just promising to show up for future court dates. The address that we will have as your official address on file, the one that we will send things to, is going to be in the upper left-hand corner. It'll take you all of a second to glance up at that and verify that it's current, complete, and correct with any applicable apartment numbers or letters, P.O. boxes, halves, rears, what have you. If you don't take the second necessary to look at it, make sure it's right and it's wrong, you're probably not going to get your notice. If you don't get your notice, you're probably not going to make it to court. If you don't make it to court, we're most definitely going to issue a warrant for your arrest, and that's a really stupid reason to be in jail. And as an aside, folks, not even an aside because I tell every group this now. We live in the age of information, folks. There's this little thing called the internet. We have a website. You can Google it up. You can track your own case and see when your next court date is, in addition to us sending you the letter. You can use your phone to call our clerk's office. Each one of them has a phone at their station and can answer any questions you might have, including when your next court date is. And lastly, ladies and gentlemen, you all have legs, and you can walk through the door that we so graciously provided to allow access into our building, into the offices, and physically talk to a person in front of you and say, when's my next court date? So if I haven't made it abundantly clear already, I do not accept I didn't know when my court hearing was as an acceptable excuse to miss your date. All right? Now, that next court date is going to be your trial. And if you decide that day, well, wait a minute, I don't want to do a trial, I just want to plead guilty or no contest, you can change your plea that day. You don't have to have a trial at that point. And you're not going to get sentenced more harshly just because you pled not guilty today. But you'll get more court costs than you would if you resolved the matter today, so just be aware of that. Now, for those of you who do intend to plead not guilty and actually have a trial and represent yourself on whatever it is you're charged with, you need to bring whatever evidence you want the court to consider with you the day of your trial. And that includes any witnesses that you want the court to hear from, because you cannot testify as to what somebody else said. That's called hearsay, and it's not admissible at trial. If you don't think your witnesses will voluntarily appear, you can ask the court to issue a subpoena, and if they're personally served with that and still fail to appear for your trial, at the very least, you can ask for a continuance of the trial at that time, but more importantly, you can ask the court to punish that person for blowing off their subpoena. If, by the way, you have evidence that you want the court to consider in the form of pictures that you've taken with your phone or video that you've taken with your phone, print out hard copies of the pictures, download the video to a flash drive or to a DVD, because if you don't and you still want those things admitted into evidence and they're on your phone, you're going to have to admit your phone into evidence. And our retention policies require us to keep evidence for 50 years. So you're going to give me your phone for 50 years? Oh yeah, and your password too, so it'll be lots of fun. So if you don't want that to happen, print out your pictures, download your video. A plea of guilty, that's another option you have. That's a complete admission of guilt. Although you're all presumed to be not guilty as you sit here, it's always the prosecution's burden to prove guilt beyond a reasonable doubt before a person can be convicted of anything. And all of you have the right to a trial, at the very least with the judge, with the jury if you're facing possible or mandatory jail time. If you plead guilty, as I said, you admit that you committed whatever it is you're charged with. Then that means you're going to give up those rights, including your right to a trial, and the state won't have to prove anything in order for me to find you guilty. If that's how you want to proceed today and resolve your case, I'm more than happy to help you wrap that up. Be certain it's what you want to do, because it's difficult to go backwards in the criminal justice system. Just to revisit a no contest plea briefly for the specific situation for speeding tickets. If you plead no contest to a speeding ticket, you're not telling me, Judge, I'm guilty of speeding. You're telling me, Judge, what they say happened is true. What they say happened on a speeding ticket is how fast you were going and what the speed limit was where they stopped you. So I will find you guilty of what's on your ticket. And if you don't believe that you were going as fast as they claim you were, or that the speed limit was higher than they say that it was, plead not guilty. Have a trial. Force the state to meet its burden of proof. If they can't, then if you be found not guilty, you won't owe any money or face any points or anything on your license. If you're found guilty, well, you'll have had a nice civics lesson in how the court system works, and you've had your day in court and had a chance to hold the state to its burden of proof. Just a couple more things. For anybody charged with the hands-free today?
No. Well.
If anybody's charged with driving while texting, which, by the way, that's actually the formal title of the statute, which is very ill-worded, because it's not like you're just texting and all of a sudden, before you know it, you were driving. There is a provision in the law that says if you're charged with that violation of the hands-free statute, having an electronic device, texting while driving, whatever you want to call it, You can take a free online class through the BMV, and that will basically waive any fine. Costs would still be imposed. This is if you were to plead guilty or be found guilty after a trial. And if you take that class and successfully complete it, you won't get any points on your license either. So if you're interested in that, ask me when you're up here, or you can ask the deputy clerk that processes your case. I mentioned points. I don't have anything to do with them. I can't waive them. I can't amend whatever it is you're charged with that carries points to something that doesn't. So if you are charged with an offense that if you are found guilty will result in points being assessed against your license and you don't want points on your license, plead not guilty today. Again, have a trial. Make the state prove it beyond a reasonable doubt. The last thing I need to talk to you guys about is lawyers. Every single one of you has the right to hire one if you want, no matter what you're charged with. If you're looking at possible or mandatory jail time, you are eligible to ask the court to provide an attorney for you for free. We will do that if you qualify. We determine your qualification based upon an application form, which, conveniently enough, you already have because it was part of the paperwork you got when you checked in. If you would like the assistance of an attorney with your case, you need to plead not guilty today. If you're going to go hire your own, start making phone calls as soon as you get home today. Find out how much it's going to be and make an honest assessment of whether you're going to be able to afford it. For those of you who intend to apply for a court-appointed attorney, turn in your application today. Do not leave this floor without turning it in. If you qualify and your request is granted, the lawyer goes ahead and notifies you of that fact. If it's denied, we'll send you a letter directly. And for those of you who are eligible to apply for court-appointed counsel but would like to hire your own attorney, fill out your application and turn it in anyway. Because if you qualify, you're going to have a lawyer no matter what. And if you are able to hire your own lawyer, they'll come in and take over. And your court-appointed attorney is off the case. What is much more common, however, in the circumstance is the person doesn't turn in their application because they're just dead set on getting their own lawyer, call around, realize that they not in any way, shape, or form going to be close to being able to afford one, and then they do absolutely nothing until the next time they're in court, which is the trial date, which is when the witnesses are here and taking time out of their day, when we've taken time to carve out of our very busy docket to accommodate your case. And then they look up at me at the from the table right there and they say, "Judge, I tried to hire my own lawyer, but man, it was expensive. Can I get a continuance and apply for court appointed?" If your case is assigned to me, the answer to that question is very largely going to be, very often going to be no, because I'm telling you exactly now, don't do that. Deal with getting a lawyer right away if you want one. If you don't want to get a lawyer, you don't have to deal with it. Don't do anything. But don't play games and wait around and hope against hope that it's all just going to work itself out. Because I can tell you, as a legal defense strategy, doing nothing and hoping things are going to just turn out fine is a pretty poor one. So whatever it is you're here for, it's not going away. You're going to have to deal with it. Putting it off longer and longer is just going to make things worse. So not trying to browbeat anybody, but the fact of the matter is you're here probably pretty much against your will, and I can't blame you for not being happy about being here. I would think that you'd want to resolve your matter as quickly as possible, but it's always important to do things right as opposed to doing them just fast. So feel free, if you have any questions, to ask when you're up here at the bench. Our first case today is going to be Randall Gwynn. Counsel, come on up. Does your client understand his rights in court today?
Yes, Your Honor.
May I have your rights form, sir? Thank you. You want to acknowledge receipt of the citation?
Yes, Your Honor.
And would you like to have it read, or you want to waive reading?
We would waive reading and any defects and service.
All right, so it looks like we've got an OVI refusal, a marked lanes violation, and a turn signal violation. How's your client wish to plead?
I plead not guilty to the charges, Your Honor.
And Mr. Gwynn, what's your current address? And are you employed, sir?
Yes.
What do you do?
I build.
Okay.
Builder.
All right, very well. Based upon the information contained in the court file and the defendant's driving history, I'll go ahead and release him on his own recognizance today on the condition that he not consume any alcohol or illegal drugs while the bond is in place. Now, this case is going to be randomly assigned to a judge, and are you making a full appearance, or is just a limited appearance for the purpose of arraignment? Okay. Just go ahead, and if you haven't done so already, submit the necessary paperwork.
Yes, Your
All right, so no alcohol, drugs while the bond is in place. All future notices are going to go through Ms. Diatley here, so it's important that you stay in very close contact with her. But this matter will be randomly assigned and set for a trial. Do you have any questions today, sir?
No, sir.
Anything further, Ms. Diatley?
No, Your
All
Honor.
right, you may go with the bailiff. Thank you.
Thank you.
Good morning, Mr. Webster. You understand your rights in court today?
Yes.
Did you get a copy of your ticket?
Yes.
Did you read it and understand it? Let's see. It looks like they cited you with only a single count, and that's operating a vehicle while impaired. It looks like they're claiming that this would be a first offense ever, which means the penalties would be as described on the video for a first-time offense. Did you understand that information? How do you want to plead?
If I plead no contest, you'll still make the judgment today, right?
If you plead no contest, after verifying that you're doing it of your own free will, knowing what rights you're giving up and what the penalties can be, I'll read through the trooper's narrative report. If what he wrote in here contains enough evidence to show that you were in fact operating that vehicle, yes, I will find you guilty, I will enter conviction, I will sentence you today. So if you don't want that to happen, you need to enter a plea of not guilty. And if you're not sure about what you want to do, then I'm inclined to enter a plea of not guilty on your behalf to leave all your options open. And then you'll have some time to figure out how you want to resolve this.
Yeah, I just don't really can't really take off work anymore, but I'll better plead no contest.
No contest. Now, doesn't admit guilt, and you're not required to plead no contest. You're presumed to be not guilty, and the state has the burden of proof. Do you understand all that? And furthermore, if you plead no contest, you're going to waive all those rights we've discussed. Do you realize that? And if you change your mind at any time, you can change your mind to not guilty if you want. But the maximum penalties that you're facing here are up to 180 days in jail, up to a 3-year license suspension, and up to a $1,075 fine. At a minimum, the court's required to impose a fine not less than $375, a license suspension not shorter than 1 year, and at least 3 consecutive days in jail, or, as an alternative, the court can require that you do the 3-day driver intervention program. So do you understand what the penalties are? All right, now, has anybody threatened you in any way or promised you anything to give up your rights or to enter a plea of no contest? Are you under the influence of anything right now? And are you a citizen of the United States of America?
Yeah.
All right, so you've indicated that you want to go ahead and waive your right to an attorney, which you're not required to do, but if that is your decision, it is required that it be done in writing. So I'm going to give you a form that says attorney waiver. I want you to actually read it before you sign anything, because I'm going to be asking you if you did and whether you understood it. But if it is your decision to waive your right to counsel, go ahead and sign by the X. You can use the table to write on. When you're finished, come on back up here, and there's a pen. All right, so, Mr. Webster, you understand this? Did you read that form?
Yeah.
Did you understand what it said?
Yeah.
Did you sign it?
Yep.
And is it your intention to waive your right to counsel? Okay, let me just finish reading through this. They stopped you at the checkpoint?
Yeah.
Okay. Okay. All right. Well, Mr. Webster, you have a right to make a statement before I make any decisions here. Is there anything you want to say? You're not required to.
Yeah.
Go right ahead.
The thing was, I told the cop I was at a little country concert thing at the bar, and I left there around 8. Is when they cashed out. And I went home with the girl, and then I took her back and dropped her off to get her car. And then I left there. I didn't go inside. I left there, and that's when I went to the checkpoint.
Okay.
So I know if they would have had a breathalyzer, which they didn't, how 5 stadiums don't have a checkpoint and don't have a breathalyzer. I don't know. And that's when all that happened.
Well, the machines that are approved for use aren't ported. They're not mobile. They have to keep them at the police stations. Okay. Where do you work?
Maintenance services.
And how long have you been with them?
Just over a year.
Okay.
And I have custody of my daughter, so if I do lose my license, I need privileges or something.
Okay. Well, it is mandatory. As I mentioned, the court's required to suspend your license for at least 1 year. You are eligible to ask for limited privileges. I'll talk to you more about that in a moment. So, having accepted your plea and having read through and found that the facts contained in the court file are sufficient to sustain a conviction, I'll enter a guilty finding. I'll order that you serve 30 days in jail, but I'll suspend all but 3 of those days, meaning you don't have to serve them as long as you follow the rules of probation. That lasts 1 year and starts today, and the main term is that you do the 3-day driver intervention program instead of serving the jail time. You'll be required to participate in the drug and alcohol screening portion of that and follow up with any recommendations, if any, that are made regarding further counseling. You're not to consume alcohol to excess, so it's not a complete prohibition, but you can't drink to excess. You can't obviously use illegal drugs or abuse prescription meds. Need to maintain suitable employment. I'll impose the minimum fine of $375, order that you pay the court costs, and I'll sentence you to, or suspend your license for 1 year. Now, that's going to be backdated to the date you got your ticket. You are eligible to apply for limited driving privileges, and you can do that today. However, you are subject to what's called a 30-day hard time suspension, which means even if you submit your application today, even if they rush it down to me and I sign off on it and approve it today, you can't use it until April the 15th, okay? So between now and then, make sure that you have arrangements made, because if you get caught driving under this type of a suspension, it's a mandatory minimum of 3 days jail, and unlike this OVI charge, there is no alternative. It's 3 actual days. And if you get your limited privileges and you drive outside of what you're permitted, like let's say you're just really hungry at night and you decide to get late night sliders, and you get pulled over, you're still driving outside of your privileges, which means you're driving under the suspension and, again, the 3 days. So if you get privileges, be very careful about making sure you're permitted to go where you're going. So, you have any other questions today? We'll give you time to pay. This isn't going to ruin your life. It's certainly going to inconvenience you for a while, but I always say the only tragedies are, the definition of tragedy is the mistakes we don't learn from. So, learn from this one. If you have any questions, you may go with the bailiff. Good luck.
So, that one. Things I learned from him. State troopers, I guess the slang for them is staties. I had never heard that before. Can I just say, I feel sorry for that girl. At least she wasn't with him when he, went through the checkpoint, because that would have been bad for her. Yeah, late night sliders. I don't know where they're served, but can't go for them on limited driving permissions. Yeah. Oh gosh, that was a fun one. That one was fun. Good night, Philip. Yeah, I'm gonna be going to bed here pretty quick, guys. Yeah, I'm gonna call it pretty quick here. Take one more trip. I'm gonna let this run out for just a few more minutes, and then we can always finish it out another night. It's not like we have to do it all in one night. But ooh, is that where White Castle? See? No White Castle for him in the middle of the night on his limited driving permissions. Oh, and that was the other thing that I found really unique about this state. I've never heard them where when you get, as part of your conditions, your bond conditions, they say that you cannot drink in excess. It's not a complete prohibition. Like, they don't say you're not allowed to drink alcohol at all. They just say not to excess. I've never heard of that from anywhere. And I'm curious to know statistically how that's working out for them.
All right, next up we have Christopher Anderson. Come on, Mr. Anderson. You understand your rights in court today?
Yeah.
All right, did you get a copy of your ticket?
Yeah.
Did you read it and understand it?
Yep.
Looks like they've cited you for two things. One is operating a vehicle while under the influence of alcohol and or drug of abuse, and furthermore, they've charged you with failure to maintain reasonable control. That second charge is a minor misdemeanor, and the maximum penalty is a $150 fine. Looks like the OVI, the allegation there is that would be the first time you'd ever been charged with that, let alone convicted. So the penalties would be as described in the video as for a first-time offender. Did you understand that information?
Oh, yes.
All right. How do you want to plead?
Not guilty.
What's your current address? Are you employed?
Yeah.
What do you do?
Elliott's right here.
And how long have you worked for them?
Like 3 years.
Okay. And what do you do for them?
I make pizza.
Okay. All right. You're going to be released on your own recognizance. You did show your proof of insurance, so I'll reflect that that's been satisfied. Until unless a lawyer gets involved, all notices are going to you, so make sure we have your correct address. Do you have any other questions?
No, thank you.
Just have a seat there on where you were before, and the bailiff's going to be with you in a moment. Good luck. Emmanuel Asangani? My apologies if I butchered your name there.
It's okay.
Do you understand your rights, sir?
Yes.
Just take that. And did you get a copy of your ticket?
Yes.
Okay. Did you read it? Do you understand what they charged you with?
Yeah, I just still understood what I was pulled over for.
So the charge itself is failing to obey a traffic control device, and specifically, it looks like they're alleging they're at the intersection of State Route 79 and Hopewell Drive, so basically down by the Chipotle and the Moo Moo car wash and the car dealership. The officer is claiming that the traffic light for northbound 79 heading up towards Newark turned red, and they claim that you were driving a black Mazda and went through that intersection after the light had turned red. So it's called failure to obey a traffic control device, otherwise known as running a red light. The maximum penalty for that offense, which is a minor misdemeanor, is a $150 fine. So, do you understand what the charge is?
Yes, I understood what the charge is.
I beg your pardon?
Yes, I understood.
Okay, and how would you like to plead to that charge?
Continuance to get a legal.
You would like a continuance to speak with an attorney?
Yes.
Okay. What is your current address? What do you do for a living?
I'm a nurse and I'm also an employer with more than 50 workers.
Okay. And where do you work as a nurse?
I'm a self-employed.
Oh, okay.
I have a business.
You like a traveling nurse?
No, I do with people with disability.
Okay.
And I also provide services for elderly.
Gotcha. By the way, you have insurance on your Mazda, right?
Yes.
Yeah, you don't, I'm going to take your word for it, okay? You didn't have an accident, and I don't think you'd sit here and lie to me, to my face, and right in open court, right?
Yes.
Okay, so, all right, so here's what we're going to do. I'm going to grant your motion to continue your arraignment. I'm going to have you come back 2 weeks from today on Wednesday, April the 3rd at 8:45. You don't have to be here as early because you don't have to watch the video again. When you get here, just hit the buzzer and say, you know, I'm a callback, or, you know, I'm here after I got a continuance last time, and then the bailiff will eventually come out and get you. But this is going to be the only notice you get of your next court date. The record should reflect that. I'm going to hand that to you now. Do you have any other questions today? Then you may go with the bailiff, sir. Thank you. Have a good day. Alexis Garrett. Ms. Garrett, come on up. You understand your rights in court today?
Yes.
May I have your rights form, please? Thank you. Did you receive a copy of your citation?
Yes.
Read it and understand it. Looks like you've been cited for speeding, going 45 in a 35-mile-per-hour zone. You've been cited for operating a vehicle while under the influence of alcohol and/or drug of abuse. You've also been charged with operating a vehicle with a prohibited concentration of alcohol, i.e. testing over the legal limit. That's basically two different theories of the same set of facts. If you were to plead guilty or be convicted, the court would only enter one conviction and impose one sentence on that. Understand? Now, there's a wrinkle on yours. So the 45 and the 35, that's a minor misdemeanor. Maximum penalty is a $150 fine. The over the legal limit charge, they're alleging that your test result was above what we call the high tier limit, and what that does is it serves to double any mandatory minimum jail term. So normally, on just a routine OVI, you'd be looking at up to 180 days, but a mandatory minimum of 3 days in jail or the 3-day program. Because of the test result, if you were to plead guilty or be convicted, the court would be required at a minimum to impose either 6 days in jail or require that you do that 3-day program but also serve 3 actual days. So do you understand? All right. Otherwise, all the penalties are the same as described in the video. How do you want to plead?
I'm not guilty.
What's your current address? Do you work? Do you go to school? What do you do?
I work. I'm a project and property manager.
All right, very well. So, Ms. Garrett, here's what we're going to do. I will release you on your own recognizance today. The case will be randomly assigned to a judge and set for a trial. Until and unless an attorney gets involved on your behalf, all notices are going to go directly to you. So, do you have any questions today?
I do have a question about this diversion program. Is that anything that I would be eligible for?
Because of the nature of the offense, no.
Okay.
Yeah. Just have a seat there in the front row. The bailiff will be with you in a moment.
Perfect. Thank you.
Kenneth Jones. Good morning, Mr. Jones. Do you understand your rights in court today, sir?
Yes, sir.
And did you receive a copy of your citations?
Yes, sir.
Did you read those, and do you understand what it is you've been charged with? Yes. Okay, so on the first citation, and this is all alleged to have occurred on the 16th at about 9:30 at night. The allegation is that you're operating your vehicle while under the influence. It's further alleged that you're operating that vehicle with a prohibited concentration of alcohol in your system. It looks like it would be alleged to be a first offense within a 10-year period. However, you're also charged with having a prohibited concentration of alcohol in your system, and they claim that your test result is also above the high tier limit, and so that would double any mandatory minimum jail term. So normally, under these circumstances, it would be mandatory minimum 3 days jail up to 180. Here it would be up to 180, but 6 mandatory days, or the 3-day program and the 3 days. Understand? How do you want to plead?
Guilty.
Now, before I can accept your guilty plea, I need to ask you a number of questions. I'm not trying to get you to change your mind about what you're doing, but rather to verify that you're doing it of your own free will, knowing what rights you're going to be giving up and what the specific penalties are, including the mandatory penalties. So, that being said, now, if I accept your pleas and enter convictions here today, I'm going to impose sentence. You're charged with 2 different theories of OVI, one that you were simply too impaired to drive, one that you tested over the legal limit. If I accept your pleas, I'll only enter 1 conviction and impose 1 sentence, okay? So for a first offense within a 10-year period as charged, it would be up to 180 days jail, up to a 3-year license suspension, up to a $1,075 fine. Any questions about that?
No, sir.
At a minimum, the court would be required to fine you no less than $375, suspend your license for no shorter period than 1 year, and because of the test result, as I mentioned, in order that you serve 6 consecutive days in jail, or order that you serve 3 actual days in jail, but also do the 3-day program. So if you plead guilty and I accept your plea, at the very least, you're going to end up doing 3 days in the jail. Do you understand?
Yes.
Okay. The 2 other charges are minor misdemeanors. As I mentioned, maximum penalties are a $150 fine. It's very likely that I would merge those for the purposes of sentencing, just meaning that they basically are describing the exact same behavior, so you can't get dinged twice for the same thing. Now, has anybody threatened you in any way or promised you anything to get you to do what you're doing here today?
No, sir.
Are you currently under the influence of any alcohol, drugs, or medication?
No, sir.
And are you a citizen of the United States of America?
Yes.
All right. I'm going to give you a pen and this form entitled Attorney Waiver. You do not have to waive your right to a lawyer, and nobody can make you do that. But if that's your decision, it is required that it be done in writing. So I'm going to give you this form. I want you to actually read it before you sign it. You can use the table to write on, and when you're finished, come on back up here.
And the diversion program is
Not available because of the nature of the offense. All right. Did you review the form? Did you read it and understand it?
Yes.
Is that your signature?
Yes.
And is it your intention to waive your right to a lawyer?
Yes, sir.
Okay, let me just finish reading what Trooper Taylor here had to say, and then I will give you an opportunity to speak before I make any decisions, although you will not be required to if you don't wish to. Alrighty, so I've had an opportunity to review what the trooper had to say about what happened. Is there anything else you'd like to say before I make any decisions here?
It's a bad decision.
What do you do for a living?
I'm a business resource manager for a box company.
Okay, and I mean, in plain English, what does that mean? What do you do?
Kind of a tech rep for different accounts.
You make sure they have what they need and try to tell them what they need?
Yeah.
Okay. And how long have you been with the company you work for currently?
The company I work for currently about 3 years. Been in the business for 26.
Okay. All boxes? Mm-hmm. Okay.
How do I go about driving privileges?
I'll go over all that with you here as soon as I
Thank you,
let
sir.
you know what the sentence is. But you are eligible to apply. Okay, so here's what we're going to do. On the OVI charge, it's going to be a 30-day jail term. I'm going to suspend all but 6 of those days, so I'm imposing the mandatory minimum. Excuse me. I'll place you on probation for a year, and one of the terms will be that you successfully complete the 3-day program. You'll get more information about how to do that through the probation officer. That'll get credit towards 3 of the 6 days, but as we've discussed, you're going to actually have to serve the 3 days. We'll talk more about you asking for a later date to come in and do that. Now, additional terms are that you're to participate in the drug and alcohol screening portion of the program and follow up with any recommended counseling, if any. You're not to consume alcohol to excess, not to use any illegal drugs, not to abuse any prescription medication, maintain suitable employment, and pay the minimum fine of $375. Costs will be assessed, and it'll be a 1-year license suspension dated as of the date of your ticket. I'll get back to driving privileges here in a moment. On the marked lanes, it's going to be a $25 fine, and I do find that that merges for the left of center, so I'm not going to impose any conviction or fine on that one. Now, as far as your driving privileges are concerned, the bailiff can assist you today in submitting a written application. I always say write everything you want to be able to drive for. If it's allowed by the statute, we will typically approve that. If your privileges are granted, and I always say if because I never promise anything from the bench, but if they are granted, be very certain and careful that you are permitted to drive where you are, because if you're not and you get pulled over, you get charged with driving under an OVI suspension, which carries another mandatory minimum 3 days. As far as the, and by the way, you'll be subject to what's called a 15-day hard time suspension. So even if you fill it out today, even if I approved them today, you still wouldn't be able to exercise those until either, I think, it'd be April 1st or so. But you can submit your application today. Now, as far as the 3 days in jail, I'm assuming you don't want to go serve your jail right now, right? Yeah, we'll go ahead and set that out. I'm assuming you work Monday through Friday typically? All right, so let's go ahead and set this out on a Friday down the road so you can make necessary arrangements. You'll be reporting here to this courtroom on a Friday morning at 11, and today's the 20th. Let's just go ahead and call it April 19th. So on the 19th of April at 11 a.m., you need to be reporting here to the courtroom, not to the jail. The bailiff will give you written instructions on what you need to do. From the moment you're brought back out of the main hallway, 72 hours later, you'll be released from the jail. Now, I want to make sure you understand the consequences of failing to report as ordered, not because I think you won't, because if I didn't, I'd have you keel hauled out of here right now, but because I just want you to be aware of what would happen. Number 1, arrest warrant goes out. Number 2, probation gets revoked. Number 3, you do all 30 of the days, and then you get 30 on top of that for contempt. So just make sure you're here. And I always say this, if you're on time, you're already late, so if I say 11, I'd be here 10:45. That being said, obviously it's going to have a major impact on your life in the short term. It won't have to on the long term as long as you make sure you don't make any bad decisions like this again. Any other questions today? Then you may go with the bailiff. Good luck to you, sir.
I was going to go to bed, but Salty Buddha just arrived, and then he had to step away to get coffee. But he's coming right back. But that means I'm going to have to stay for just a few more minutes. Just a few more minutes, guys. And then I'm going to go to bed.
Denise Kreller. Ms. Kreller, come on up. Morning. You understand your rights in court today?
Yes.
And did you receive a copy of your ticket?
Yes.
Did you read it and understand it?
Yes.
You have been charged with speeding, going 70 into 55. It's a minor misdemeanor. The maximum penalty there is a fine of up to $150. You've also been charged with driving under an FRA suspension. That stands for Financial Responsibility Act. And they're not alleging that you have at least 2 priors within the last 3 years, so that's still an unclassified misdemeanor. So no jail on that either, just the possibility of community service, a fine, and a suspension of your right to apply for a license of up to 1 year. No mandatory penalties with either of these offenses. Understand? How do you want to plead?
Guilty.
Do you understand the nature and consequences of that type of a plea based upon my explanation?
Yeah.
And are you a citizen of the United States?
Yes.
Alrighty. Anything you want to say about what happened? You don't have to, but you have a right to.
No, I was just, I drive from Zanesville to Newark 5-6 times a day. And yeah, that drive is excruciating.
Well, here's the deal. You're really not that far. Now, I'm looking at an unofficial printout of your driving abstract, and don't go based on what I say, go based on what the BMV says, because that's who you need to get in touch with. But according to what I see here, the only thing that is holding you back from being valid is getting an SR-22 high-risk bond and paying a reinstatement fee.
I did that.
So are you valid now?
Yes.
Okay. Well, before I can accept your plea as far as the DUS is concerned, driving under suspension, I want to make you aware our prosecutor's office has a policy that if you plead not guilty to that charge today and you come back for your next court date, which would be a trial, if they verified that you in fact are valid at that point, whether you were valid then or not, whether you're valid today or not is irrelevant. It's if you're valid on the day of your next court date. Their policy is that they'll dismiss the charge in exchange for your willingness to pay court costs. And if you're interested in doing that, then we should enter pleas of not guilty today.
Okay.
You want to do that?
Sure.
Okay. What's your address? I'm going to do not guilty on the speeding ticket as well. Whether you're valid or not will have no bearing on them going forward on the speed. So if you just want to change your plea to the speed and get the other thing dismissed, you can do that. Or if you want to have a trial, you can do that too. And you showed your insurance, so you're in good shape there. So this gets randomly assigned, set for a trial pretty quickly, and we'll get you notice through the mail. Any questions?
Nope.
Then you can have a seat in the front row, and the bailiff will be with you in a moment. Good luck to you.
Okay, so just in case I don't get back to running the rest of this docket, I have to play the last hearing. I have to. So bear with me for just a second while I get to her.
All right, if you're not Devonna Rollins, we're in trouble. Is it Devonna?
Yes, you got it right.
All right. And Ms. Rollins, do you understand your rights in court today?
Yes.
And did you receive a copy of your ticket?
Yes.
Did you read it back in the day, and do you understand what it is you were charged with?
Yes, I don't agree fully, but yes.
Okay, well, they're alleging that you were speeding, specifically going 82 miles an hour in a 45 mile per hour speed zone. It's a minor misdemeanor, and the maximum penalty there is a fine of up to $150. There's the possibility of up to a 1-year license suspension, but it's not mandatory. Understand?
Yes.
How would you like to plead?
Guilty, no contest.
Okay, well, there's a difference between the two. The end result's going to be the same, but getting there's a little bit different, so you kind of have to pick one or the other. Would you like guilty or would you like no contest?
Guilty.
Okay. Now, you realize that you're not required to plead guilty. You're presumed to be not guilty. The state has the burden of proof, and you have a right to a trial with the judge, right? And if you plead guilty, you give up all those rights. The state won't have to prove anything. If I accept your plea and enter a conviction, I'm just going to impose a sentence. Understand?
Yes.
And lastly, Ms. Rollins, are you a citizen of the United States of America?
I am.
All right. Let me take a quick look here. All righty. Okay. Anything you want to say about what happened? And you're not required to.
Yeah, he was lecturing me so bad. I got it, I get it. And then he was like, you know, you're going 85, and I was like this was, he said it, he gave his lecture. He's like, I'm going to go back to my car, write your ticket up. I said, okay, cool. He comes back, he asks why my son is out the seat. And I was like, we told you we have to go to the bathroom, like, really have to go. And then he was like, yeah, you were going 85, and I was like, no, I kind of think you got me at like maybe a 60, 65. And then he was like, yeah, I clocked you at 68, but you're yelling at me about 85. So it was then, and then I was like, it was like, what's in your bottle? And then I was like, pee.
Oh, okay.
And it was funny because my son goes, I told you could have peed in a bottle. And I was like, that is for boys. Mom,
How old's your son?
he's 8.
Okay, all right.
We take trips a lot, so it's easy for him to go pee. So I was like, it don't work like that for girls, boy. But no, I plead to everything.
Well, your record, your driving record isn't bad. You haven't had a moving violation in almost 6 years, right? So,
I promised my grandpa I was done, so.
Now, you keep insurance on the Volkswagen, right?
No.
But you would in a perfect world, right?
Yeah.
Okay, well, that's good enough for me because you didn't have an accident, so there's no sense for the Bureau to come over for no reason. So, I'm not going to impose a license suspension as a component of your sentence, but I will hit you up with a financial sanction. Are you employed?
Yes.
What do you do?
Ohio Department of Medicaid.
Okay, so you work for the state?
Yes.
Okay, well, so do I partly. Oddly enough, I'm funded. My salary is funded by the state, the county, and the city. So, anyway, $114 plus court costs. Any questions? No. All righty. If you have no further questions, then the bail's going to take you to the clerk's office. We'll give you time to pay on that, okay?
I can do it now.
If you can pay it all, I'd rather have your money sooner rather than later, okay?
Thank you.
All right, court stands in recess.
Yeah, the judge didn't, it didn't seem like he could end that fast enough, and I don't blame him. She really was, but that was a bit TMI. Officer said, what's in the bottle? Pee. She was cute. I just had to show you guys that. Just in case I didn't. The other ones in between from there to the end were a little bit interesting, but nothing like that. Yep. All right, guys, I am going to go to sleep. Well, hi, Billy. Hi, baby boy. Thank you guys for coming out and having such a good time with me. It was so much fun, and I love you all. And I hope you all have a wonderful night, the happiest of Easters. Those are dog biscuits, Billy. Those are not kitty treats. Those are doggy treats. Don't grumble but me. I love you. Hold on. I don't know if everybody's seen yet or not. Billy. Come here. Come here. Not going to do it? You're grumpy? He's very grumpy. Y'all should see the looks I'm getting. Those are dog biscuits. Those are not cat biscuits. Oh, I'll show you guys another time. But thank you. Thank you all. And for everybody who bought gifted memberships and for the super chats, I really appreciate it. I do. You guys are the absolute best. I have the best chat on the entire YouTube. The whole YouTube's, Billy. All of them. Every YouTube's. Hey, Billy. Oh, I got my kiss. And you get your treat. Earl, do I get a kiss from you? That would be a perfect way to end the stream. Earl. Thank you. Oh my gosh. This is the best. This is the best. Billy. Billy. I'm not going to get another one? Not going to give me a second kiss, huh? All right. I'll be grateful for what I got. Hold on. No. Thank you. I love him. He's so wonderful. Oh, you're welcome, Patrick B. Thank you for being here and for being my friend. Yes. Best people ever. Yeah. All right, guys. Be safe, be well, sleep sweet, and much love.